My lord, I may beg your pardon to mention on admission matter, my lord.
Which year?
23.
23.
Yes.
Week of the feast.
In this matter, the stay is continuing against me, my lord.
Let it come.
May mention on the virtual mode.
This admission matter, Lordship, kindly listed to.
Which year?
2025.
25
matter, black mark has been made.
Your Honor,
Pardon, my lord.
Yes. Number 87.
Huh?
87.
87.
The leave has been transferred. I am for the appellant. I have taken consent from the other side. May I pray take my ready after 3 weeks, my lord?
3 weeks.
My lord.
Are you preparing for Keshwananda Bharati
Because
argument?
no, it's a bulky brief. That is why
The next week you do it.
No,
The 2017 matter.
2 weeks after.
2 weeks.
2 weeks after.
Your Honor, item number.
Item for the final. The request of for the petitioner.
Your Honor, item.
Madam to mention, as a matter relating to appointment of Ganashikaka. The opposite party commissioner of
Which year?
2015.
2015.
Till that, no counter has yet been filed.
Next week.
Both the cases.
Your Honor, item number 31. I have filed withdrawal memo.
During my seniority,
Item number
the
31.
state has engaged my junior most of the teacher as a principal in charge of the institution. That is subject matter challenge.
When it happened?
Lordship and Wednesday, Lordship.
When that matter was?
This matter is of 2023.
23 week after next week.
Your Honor, item number 31.
My lords, may I mention the virtual mode?
27, my lords. Of which year? Everybody should mention the year.
25.
20.
Item.
2 weeks at the request of 3 weeks at the request.
Your Honor, item number 31. I have filed the withdrawal memo.
1 second, you wait. Well, first preference to those who are before the court. 5 marks extra to them. Yes. The hearing or this matter. Yes.
Item 16, my lord, 60, page 11.
60.
My lords.
Which year?
23.
23. 3 weeks at the request. 3 weeks at the request. My lord, your friend.
I have already informed Mr. Bikenanda.
My lord, 2023 writ matter in which an interim order was passed against me, due to which I was unable to withdraw my gratuity and
What you want?
my lords, I have filed a vacation petition. My lord, let it be listed.
It is not listed.
No, my lords.
Okay.
Lordship, may I mention virtually?
There is one article provision added during Indira regime to Article 256, where an application is moved after serving a copy on the other side and court does not pass any order within 2 weeks, then the interim order is deemed to have been vacated. There is such a deeming, constitutional deeming, that just look into that also. Yeah.
Lordship,
You mentioned the matter. It's for fresh admission, your lordships. For the matter to be listed, your lordship, Mr. Merusagar Samantra is appearing virtually in this matter, your lordship.
yes. May I mention, Lordships? Well,
Yes.
matter by the Gas Authority of India Limited, that they are laying pipeline through Jajpur, Lordships. And
You are arguing, it's what you want.
I'm listing tomorrow is urgent matter, my lords.
Which year?
Fresh matter, my lords, of July. We have filed it on 30th of July. But that is
This fresh matter.
fresh matter.
They will come next week there, because tomorrow we have posted many matters. Next week.
The execution proceeding is going on, my lords. That is my difficulty, Lordship. Any day this week, Lordship.
The Friday. Thursday.
Grateful, Lordships.
Item 73, my lords. I will file rejoinder, my lords. Friday I received the counter.
Friday you received it.
My lord, 73, 2 weeks after.
Have you informed your friend?
My lords, state is only.
Okay, 3 weeks at the request.
My lords, 73.
Page 1. Item number 1.
Your Honor, withdrawal memo. I have item number 31.
31.
I have filed 31. I have filed the withdrawal memo.
Which one? 31.
I pray for withdrawal.
Yes, 31. Counsel for the petitioner has moved a memo dated so and so seeking leave of the court to withdraw the petition. First off, proponent. State.
Fresh matter.
State.
Union of India.
But same matter. Union. Leave having been accorded at the admission stage, petition is permitted to be withdrawn unconditionally. First, ordered accordingly. Registered to send a copy of this order to the respondents by speed post for their file.
Authorized.
Yes.
Yes, ma'am. May I please also?
Yes.
When the petitioner filed this writ application, praying for a direction to the opposite partner 1 to consider the predicament with petitioners who are ex-employees of OTM Chaudhar and allotted peaceful and within Chaudhar municipal area to each of the ex-employees of OTM. So, yes, that annexer 1 at page 26 is pending for the OP number 1, my lord.
What you have sought for there?
I have read one petition.
You have sought for?
Petitioner are the ex-employees of the Orissa Textile Mills at Chaudhar, my lord. And they have prayed for the government to allot a piece of land because in view of the closure of the OTM, the government has taken a decision to oust them by paying a paltry amount. They are residing there for the last 60 to 70 years. And they have already applied a paper of made representation for the authorities to consider. That representation is pending.
You are right. Get the land of the government.
My sole prayer, the representation may be dispersed in a constitutional law. Stipulated.
What is your right to get the allotment? Which policy?
Policy because their vast land is lying in the Chaudhar municipal area, my lord. The vast land is lying in the Chaudhar municipal area. They applied for they only prayer to consider and disperse the representation according to the law.
You can't direct that representation jurisdiction.
Yes, I can compel my authority. My representation is pending. That is my only prayer to consider. Only.
The petitioners are knocking at the doors of writ court, seeking consideration, seeking a direction for consideration of their representation dated 21/11/2023, wherein they have sought for allotment of a piece of land that belongs to the state. First up. Next paragraph. Learned counsel for the petitioner vehemently submits that the prayer petition is very innocuous and beyond seeking an order to pass an order on the subject representation, nothing is claimed, and therefore this court should come to the aid of his clients. First one. Learned AGA appearing for the respondent opposes the petition, contending that there is no demonstrable right to consideration, property being of the government. First one. Next. Having heard the learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter inasmuch as the claim is to the public property and no right prima facie is demonstrated to the grant of the same. First up, it was Hugo Rocius who said that belongs to all, belongs to none, and that belongs to none, belongs to all. First up, a public property, the constitutional courts are under duty to protect for the benefit of public at large. First up, unless a rule or ruling is cited to support consideration of representation of the kind, merely because it is a representation, court cannot direct its consideration. First, in the above circumstances, petition being devoid of merits is liable to be and accordingly rejected. Courts having been made easy. Next. Item number 2.
Group D employee of Uri Junior College, my lord, ACS Junior College, continuing ad hoc basis 1990. This Hon'Ble Court, I was given temporary status in Annex 7 in the
What's your prayer, sir?
for regularization.
Regularization.
Earlier, it was this Hon'Ble Court directed for regularization to consider regulation in light of a similar case passed by this Hon'Ble Court in Basant Barik's case. That is in
they rejected it.
No, they have, instead of giving regularizing me, they again passed an order giving temporary status, which I was given in 2012. That order is at Annex 11, page 26.
You take notice, brother.
Notice, they had earlier taken instruction 3-4 times it listed, my lord.
Well, earlier they had appeared.
Yes, my lord.
Where is that? Who appeared?
Government had taken time to take instruction.
But take instructions and file a short name is Niranjana Dixit.
Yes, madam.
Any related to me anyway, except sharing my name. Issue notice. Learned AG accepts notice for the respondents and seeks a short accommodation to file the.
He is going to retire within a year, my lord.
Counter. First, call this matter in the second week of October 2025. Finally. Yes.
Item number 3. I would on for lordship. Well, it's a matter where the petitioner is a prematurely retired with effect from 17 to 2021, my lord, is challenging the premature retirement order and the subsequent rejection order, my lord.
Premature retirement. How many years of service he has put in?
My lord, almost 30 years of service.
30 years.
Well, here what has happened
30 years you are prematurely retiring.
No.
Who is the respondent?
My lord, respondent is the government only, my lord.
30 years service he has put in. You had no problem for 3 decades and all of a sudden he becomes bad employee.
And my lord has recently delivered a
case.
Yes, my lord. Yeah, what my lord had held in that is that it cannot be a shortcut to the disciplinary actions, my lord. And here it is completely that case, my lord. They have issued a show cause.
Learned counsel Shri so and so, who succinctly made out a case for issuance of notice. First off, issue notice. Learned AG is requested to accept notice for the respondent. With effect from what date he has been removed?
My lord, 17 to 2021, my lord.
21, my lord, but not a case for interim order. Let us.
My lord, and another one, the last order, if my lord may see, this Hon'Ble Court has passed. Employee who was in the review committee, who was there, his case was being reviewed, he has already been reinstated in service, my lord, by the virtue of the court order.
Let us.
If my lord may just indicate.
Let him file
my lord, if my lord may just indicate that her name, that specific instruction can be taken if she is similarly placed in RET.
You give that copy to him.
My lord. Much obliged.
Counsel's submission that in an identical set of circumstances, a particular employee is reinstated is noted.
Much obliged.
Item 4.
My responsibility with his due diligence before lordship, my lord, petitioner's daughter who has attended class 10 examination conducted by CBSE board, my lord, she preferred this read before your lordship, seeking the revaluation or rechecking of the class 10 English paper only, my lord. My responsibility before your lordship that the awarding grace mark is also not
from Delhi. You from Delhi? Which place you are?
I am placing before your lordship at Puri, my lord. Puri Justice, my lord.
You are from Puri?
Puri Justice. So the case is like this, my lord. I drawing the attention of your lordship, please make a glance to para 2 of my petition, my lord. The
admission is, these are all fresh admissions, na?
Yes.
My lords, I may be permitted to submit.
You appear for university?
For the CBSE, my lord.
CBSE?
Your lordship has This honorable court had passed orders on 23/4 to copy to be served on me, and I have received copy on 13/6.
One time.
13/6/2005, and I have entered appearance on 27. My counter is ready. If your lordship permits me.
Which date you want?
1 week after.
Your friend wants to file a counter at the request of learned panel counsel appearing for the OPs. A period of 2 weeks is granted for filing the counter if any. Next.
Item 5. Here, my lord, petitioner is an advocate who is engaged in additional government pleader, my lords, is before your lordship for getting his professional dues, my lords.
Professional dues?
Professional fees, my lords, from the government.
Not paid to you?
Yes, your lordship.
Why,
my lords, the government has taken time 3 times, my lords, to take instruction.
It may happen to you.
I have not.
After your tenure. Ask them why they are. See, is there any problem? Next date you have to say that.
But since February,
it's lawyer's money.
Yes, sir.
You can't do that. So can he go to civil court for getting that money? This does not behove well to the state. What will you do? Any representation?
Yes, your lordship.
But if I say consider, they may reject also.
Yes.
That will be useless.
Yes, your lordship. That
because you have not seen one case where you have brought before me, sir, you have directed consideration of representation. We have granted the relief to the litigant. One single case. Therefore, considering representation will not help nowadays. You tell next week. Week after next?
Week after.
Yeah. The short grievance is as to non-payment of prescribed fees to a government council. Then, despite representation, first of all, this is not a happy thing to happen. First of all, next paragraph, at the request of learned AGA, who wants to confer with the officials and come back with the instructions, a period of 2 weeks is granted. Finally, matter to be looked into in the meanwhile, whether without intervention of the court, the payment can be made. First of all, just look into it. Put it before the concerned secretary. Otherwise, I may order double the amount. And that amount, state will go, give, and excess amount, it will recover from the secretary's salary. Yes.
Lordship may fix a date so that
next it will come. If it does not come, move away. I remember everything in the court proceedings. Okay, just you can just. Yes.
Item number 6.
Please, my lord.
Yes.
My lord, here the petitioner is also a retired employee appointed as a lecturer in the Lingaraj Law College in the law faculty. Only the prayer of the petitioner to provide that academic grade pay, AGP. Suppose a person who also completed more than 4 years, he is entitled to get the academic grade pay. And the present petitioner got appointed in the year 2001, and he is entitled in the year 2006 pursuant to their notification, that is Annexure 2 and 3. Annexure 2. May I draw my lordship's attention? Page 27.
Have you made the representation?
Yes, repentance they have denied.
They have denied?
Yes.
What ground they have denied?
Sir?
On what ground they have denied?
Only simply says no, your representation has been considered and we are not allowing the academic grade pay. That is only simple says.
So, one second. Sir, I have to stop after each sentence.
Sir.
Is it not? I have to assess you.
Yes.
Whether they have given that benefit to others.
Yes, because they have sir, Annexure 2, they are clear their notification. Sir, their notification, I am entitled.
No, your entitled is one thing.
Sir.
My question is.
Yes, they have given to others.
Where have you stated in your petition?
No, I have not stated in my petition.
You can't argue what is not stated in the petition.
Sir.
You are liar.
Sir.
You cannot say something what is happening in the market.
Yes.
In Bhubaneswar market and say.
Sir.
Yeah. You take notice,
Barampur
University issue emergent notice, returnable within 2 weeks. Notice by speed post returnable within 2 weeks. First, in addition to taking usual steps, petitioner is permitted to serve a copy of the petition on any of the panel counsel, usually representing the university.
Puripati 2 to 5. One is state.
And can survey copy to the state right now.
Why state is a party?
Because that is that notification issued by the state.
No, if notification issued by the central government, you will make central government also party. Your rights arise under the notification.
Without making state as a
they will not post only.
No, I cannot file the writ petition.
No, I do not understand this. Anyway, issue 3, learned AG accepts notice for first respondent. Not for remaining, then okay.
I beg pardon, my lord.
Famous judgment of the apex court, 1958 Supreme Court. Who should be made a party? Who should not be made a party? Rajia Begum versus Shahnaz.
Yes. A leading decision. I love decision. By today or tomorrow. Lovely, sir. Lovely.
Item 7. This petitioner was a Ganasikhar. In accordance to Annex 1, he was appointed. Thereafter, he has been regularized. In accordance to Annex 3, my lord. Annex 3. This petitioner was regularized with others. But my serial number is 68. Running page 20. 68 Koira. My name is Nishikant Mahakul. My date of birth 4th April 1970. Category SCBC. My school is name is Samua PPS. Date of regulation 1st March 2017. But till that, no any my salary has not been allowed since this date.
From 2017, no salary is paid to you.
No. Only I am getting that salary applicable to the Ganasikhar.
What else needs to be paid to you?
The regular scale of pay.
Regular scale of pay. Which is that regular pay scale?
That is in first paragraph, running page 18.
18.
Madam. Second paragraph. They are provisionally appointed without prejudice to the claim of others as labeled be assistant teacher.
Rupee
200. My lord.
In that pay scale, they have not given to you 5,200,
No,
20,200.
No, my lord.
Yes, issue notice. PGA is requested to accept notice for the respondents. All respondents?
No, man, one.
One respondent. Only one respondent.
Sorry, all respondents.
All respondents. Just looking to that why salary is pay scale is prescribed. Salary has to be on the pay scale. Pay less than what the pay scale prescribes.
He has not been regularized.
Well, he has been regularized from 1/3/2017.
And another thing is he has not passed the OTT exam.
Is it a precondition for drawing salary?
Yes, Annexer.
Can be increments, I understand.
Annexer 7-year-old.
Annexer 7?
Yes, he has challenged this. He has challenged both our final order against Annexer 6 and also Annexer 7.
What is that?
You know, file counter.
You have not passed OTET.
My lord, not passed.
Then what is the what he says is correct?
My Annexer 5, that the government getting notification also has that according to that not required for regularization. Annexer 5, running page 25. This gazette notification, wherein it is prescribed that what is not mandatory for regularization.
Not required.
Not required. I have already been regularized.
Read
that exact para is that Government page 26. B. Sir, government sector is required to pass OTT within 31st March 1990. If he has not passed OTT earlier, if she has not possessed OTT by such date, he will not be able to get any further increment after that.
Only increment?
Only increment.
Not the pay.
Not the pay. That is also decided in Bharavaddhamaji case.
Issue emergent notice. Learned AG to accept notice for the office and come out with short counter in the next 4 weeks. Since matter lies in a very narrow compass. First one. Call after 4 weeks. You are right.
Item 8. 8 is identical.
8 is also same.
Identical. Same question, district also.
7 and 8 together. Same order.
Item 9.
What is that memo?
My lord, petitioner is a trained graduate.
How is your health now?
My lord.
Is it well? Are you well now?
Somehow.
Somehow. And argue also. You can sit and argue also.
No. I am okay. My lord, the petitioner is appointed in pursuance to the order under Annex 5 and 6. Passed in compliance to the judgment passed by this Honorable Court under Annex 4, my lord.
Devi Kumari.
Devi Kumari. Rangala Devi Kumari.
You take notice? Yes. AG is requested to accept notice for the respondents. Matter lies in a narrow compass. All this matter after 6 weeks.
Right.
Any entry model is? No. Item 10.
Obliged.
May I pledge your lordship?
Yes.
But the petitioner, being a lady entrepreneur, was allotted with a piece of land of 3 decimal in the IDCO, Industrial Development, the organization set up by the state government, IDCO.
Industrial Development. CO?
Man.
CO is? IDCO you say?
Yes.
Means what?
That is brought.
How to teach me also?
No, sorry. No.
Yes. Lawyer, the judge should. Judge is more like a student at your hands.
Corporation, they have not acquired the land.
You are not answering.
Sorry.
IDC you answered. Industrial Development Corporation. OE is what?
Odisha.
Odisha
Infrastructure.
Yes. Milord, the petitioner allotted with a 3 decimal of land.
3 decimal
of land.
Means how much?
3 decimal means, Milord,
how many square feet?
1300 square feet.
1300 square feet. It is like around 33 into 40.
Here in 1 gunt, suppose 1 gunt is about 1740 square feet.
1 gunt.
And that is gunt is equal 4 decimal is equal to 1 gunt. Gunt means per acre there are 25
is 33 into 33, 1080 square feet.
That is 1100 to 1200 square feet. 1200 square feet land. 3 decimal.
No, 1089 feet.
Right.
Yes.
To set up a fabrication unit. And accordingly, the premium was paid and the land was allotted in our favor. For expansion, because since land was not adequate for the purpose, since some vacant lands were there of the IDCO and they are also giving land by taking premium, she applied for another 2 decimal of land. In a portal.
They rejected it.
No, they have kept pending.
We'll direct them to consider the representation.
Thank you, Lordship, please.
Perfect. Petitioner, kindly be Basanto. Petitioner, a gentle lady entrepreneur, is knocking at the doors of Reed Court, seeking a direction for consideration of a representation dated. Sit down and say.
7th of March 2025.
7/3/2025. A copy whereof avails at Annexure
5 series, Millard.
5 series.
To the managing director, IDCO.
First one. Next one. Learned counsel for the petitioner argues that an entrepreneur has to be with additional land, keeping in view her progressive entrepreneurship and despite representation, no decision is taken by the OP number. Sit down. OP number 4. Who is the competent authority? First one. He draws attention of the court to Article 350 of the Constitution of India, stating that where a citizen airs his or her grievance in writing, the competent authority has to grant redressal to the said grievance in accordance with law and within a reasonable time. This having not happened, he says, court should come to the aid of petition. Who is the respondent?
This plaintiff is, and it's their
And for opposite party, they have one panel, madam.
One panel. We'll direct them without this one. Let them consider.
Yes.
You send that order with your letter. Lovely DGA on request accept note. OP number 1. OP number 1. First up, and submits that the decision has to be taken by other OPs. First off, be that as it may. First off, since innocuous order is being passed, to pass order on the representations in question, notice to other OPs is dispensable. First off, next one, in the above circumstances, petition is disposed of, directing OP number 4 to consider the subject representation within an outer limit of 8 weeks in accordance with law and to inform result of such consideration to the petitioner within 1 week thereafter. First stop. Now, no cost. Registry to send a copy of this order to by speed post to OP number 4 for consideration and compliance. First one, all conditions are kept open. First one, it is open to OP number 4 to solicit any information or document from the side of petitioner as are required for due consideration of subject representations. Semicolon. However, in that guise, delay shall not be proved. No cost. Yes, no cost. You can read this. Okay. We have copy to be acted upon. Same order. Where dismissal is done, you need not worry. Where some relief is done, take your order. We have copy to be acted. Around sentence. All contentions are kept on. Item 11.
May I please, madam? Yes. Listener is praying for a direction to the London SD, Court of XDJM. Dispose of the case which is pending before him since 2015, Your Lordship.
2014?
My lord.
What is that case?
498, template case of matrimonial dispute arising.
My lords, I question the maintainability. Criminal motions is not assigned, cannot be adjudicated in a civil writ petition, my lords. There is a proper forum, my lord.
You'll post it before the other bench instead of going through all that examination. Registry to reclassify this matter and post it before the roster bench immediately. Item 12. Yes.
In this case, the petitioner was appointed in the year 1984 non-government educational institution. His head school was taken over.
Payment of gratuity?
My lord.
Not paid, gratuity not paid.
Gratuity paid, but only government period gratuity has been paid, non-government period they have not paid.
For non-government period also gratuity is payable?
My lord.
Is it true? Which rule? Which rule?
81 rule. The headmaster of the school also
Proposal submitted proposal before the DO, Annexure 6. Page 17. Page 17.
If they consider that will be all right.
Only.
The short grievance of the petitioner is as to non-consideration of his representation, wherein she has sought for payment of gratuity for a particular period. First off. Next paragraph. Counsel for the petitioner submits that gratuity is a terminal benefit and it is a matter of right and therefore cannot be denied. First off. Learned counsel, on being asked whether his client will be satisfied if a direction is issued to consider the subject representation, he says yes. First. Next paragraph. In the above circumstances, petition is disposed of, directing consideration of subject representation at Annexure 6. Correct? Dated?
Annexure 6 is the proposal submitted by the headmaster before the DO.
Where is your representation?
My representation is Annexure 7, page 18.
Annexure 7 dated 18/7/2024. In the light of proposal of the headmaster sent to District Education Officer Khorda at Annexure 6. First time. Time for compliance is 8. First time. All contentions kept open. Next, it is open to respondents to consider. You have to show the name of the government agency. Item 13.
My lord, this matter.
Yes, yes, sir.
My lord, this matter has become infructuous.
Infructuous?
My lord, we had prayed for obtaining certain certified copies of the certain.
They have been furnished to you.
They have been furnished to us.
Learned counsel for the petitioner submits that the petition has become infructuous in as much as the prayer has been met by the jurisdictional authorities. And therefore, she seeks its disposal as having become infructuous. First off, next paragraph. Ordered accordingly, and she needs disposed of. Item 14.
The present writ petition filed challenging the inaction of opposite party in the matter of sanction of RACP.
Sanction of?
RACP.
RACP.
Well, it is covered under Ashok Mahapatra agency.
Have you given the representation?
No, my lord.
But you have to give the representation.
Yes, my lord. Well,
you give representation, in the light of this, they will consider.
Oblige, my lord.
Petitioner seeks, petitioner has scripted his main prayer, number 3, you have to pray. As under. Next paragraph. On being asked whether the petition precedes the presentation of a representation, learned counsel for the petitioner submits that he would advise his client to give one within 2 weeks and a direction be issued to consider the same within next 8 weeks. First off, with this proposal, learned AGA is appearing for the respondents is agreeing. Next paragraph. In the above circumstances and with the above observations, petition is disposed of. All contentions are kept open. No courts. Item 15. One said, which is that judgment, brother? You said if the disposed. It hardly needs to be stated that the subject representation in contemplation.
The judgment is
considered in the light of
Ashok Kumar Mahapatra, State of Orissa.
Coordinate bench decision.
This is Supreme Court judgment, my lord.
Supreme Court judgment. And the
is covered under
Supreme Court decision in
that coordinate bench judgment was
this is a judgment. Annex 1.
In terms of coordinate, in terms of apex court decision at Annexure 1. Item 16. Copy to be acted upon. Yes.
16, my lord. This is second round litigation, my lord. Your lordship passed in a similar matter issue notice. Notice. This is the case of Ganashikshako claiming similar benefit of Shiksha Sahayak. Dhananjay Charan.
Column. Issue notice. Learned AG accepts notice correspondence. Any private party?
No private party, my lord.
Call this matter along with WP number. Next.
Item 17.
Appears covered by Ashok Kumar Mahapatra.
My lords, but no cause of action, my lords. Kindly see 2 pages annexed. One of the circular of 2011.
But anyway, he has quoted Ashok Mahapatra judgment. In the light of that, you have to make the consideration.
Unless
you take notice. You take notice and say your version. Emergent notice. Learned AG or sub notice for response. Next.
Item 18.
May I please, madam? The petitioner applied for the post of contractual Hindi teacher in the year 2014, my lord, 28 October 2014.
Applied for
the post of Hindi teacher contractual, my lord.
On contract basis.
On contractual basis, my lord.
All teachers are taken on contract basis.
On 2014, as per 2013 rule is there, a contractual rule was there, my lord. In 2013.
They have made a rule only.
A rule was there that has been repealed, my lord. Now, in 2022, that has been repealed.
You applied on?
I applied, my lord, on 27/10/2014. Well, my application was not considered on the ground that I was not having the requisite qualification. I appear before the Lawrence State Administrative Tribunal along with batch of cases. Lawrence Tribunal allowed the original application, indicating therein that I have the requisite qualification as per the advertisement. So you issue engagement order in favor of all these persons, including the petitioner, my lord. A review application was filed by state government in the original application.
Rejected.
That has been rejected, my lord. That has been what has happened in 2019 after abolition of the state.
Came to High Court.
Came to High Court, and this honorable court rejected the review application. A writ appeal was filed. Review that has been dismissed. Matter went to Supreme Court. That has been dismissed. Now, my lord, what has happened in 2024, when 2022 rule has been repealed of contractual, now they are issued a contractual appointment in 2024. Instead of issuing a regular appointment, because 2022 rule says if any person was appointed in pursuant to the rule of 2013 contractual, they have to be taken as a regular employee from the date of the notification published of regular engagement.
But you were not taken.
But because of the latches of the authority, my lord.
That's all right.
There is a provision in 2022. They have to take as a notional basis by calculating the period. They have to take notional because 2014 my lord advertisement was there. Because they did not consider judgment was implemented.
No contempt was filed.
No, my lord. Because they issued in 2024, my lord. After disposal of the Supreme Assembly.
To take note.
This is the only
arguable points. I don't know any considerations.
My lord.
So, emergent notice. Learned AG accept.
I have also filed this presentation that I have also filed, but let them.
If they consider it,
no, they will not consider. They will not consider.
They will quote that rule and say you are not entitled. Okay.
Very pattern. I don't say 17. No, disposal.
70. You have given representation.
Higher value sensitiveness.
Which matter you have? You want? 17.
My lord. Ashok Mahapatra, university disposal similar matter.
Saying?
No representation.
Representation is not given. You give one representation.
My lord.
That is RACP.
RACP, my lord.
Good. The same order, RACP order.
Item 15.
15. Print item number 15 in 17.
No.
15.
16.
Where not mine? 15 Passover.
16.
17. Which in that case, just we said 14. Print in 17. But show name of the AG also. Yes.
Item 19, same also, Mahatma. 19
also.
And 22 also.
19, 22, same one. Any other matter is there? No. Item 20? No, 18 you have left, na? Issue emergent. Yes.
May I please, Your Lordship? The matter is relating to engagement of Hindi teacher in primary schools, Your Lordship. In similar matter, Your Lordship, they issued notice.
This is what? Issue, serious. Issue emergent notice, AGA to accept notice for the respondents. Call this matter along with WP number.
Keep forward down.
Yeah, your copy.
20498.
Yeah, WP 20498 of 25.
Item 20.
Huh? Correct.
Yes, yeah, sure. Much obliged.
Yes. Item 21.
May I please, Your Lordship?
Yes.
Annexure 3 is pending before OP number 2. Eviction. This is a government gochar land. And there should be a big under the OPLE Act matters. My prayer is due process of law. Annexure 3 is pending before OP number 2.
What that is for?
That 1100 acres land are there. Respect to RCB, there should be a big as per the law. Odisha Prevention of Law and Encroachment Act. I filed a representation before the OP2, which is pending annexure 3, my lord.
So what is wrong in that? It's not your land.
No,
Quit it. We'll give you some time. Otherwise, I'll dismiss the petition.
There should be
There should be
process.
that is you are unauthorizedly occupied and unauthorizedly you are being evicted.
But 1100 acre decimal lands are there.
If you want some time, we'll give you. You have to quit the government.
Because out of they only want to evict me only.
Don't let him. It is like one thief saying, out of 100 thieves, only I am being caught. You are the robber of the government land. What is your right?
Odisha Prevention of Land Acquisition Act, my lord.
That's how they.
As per Act, they evict me. No problem, my lord.
None. We will not. Not for meant for people like you.
My representation pending for the.
It may be pending. That makes no sense. You tell me, if you want some time, I will give you. Otherwise, I'm saying you should be immediately evicted.
Represent
the government land. Not
adjourn.
Why adjourn?
I have taken time. I have pay for matter.
No, you have already argued the matter. No time will be granted.
No, my prayer is limited prayer.
You have said that. Tell something new. You can't chant it mantra.
I have something new. The OPLE Act, and I will satisfy Lordship.
Petitioner is knocking at the doors of the court with the following prayer. First stop. Next paragraph. Learned counsel for the petitioner submits that his client is in settled occupation of the government and therefore he cannot be removed unceremoniously, disregarding his representation. First, next paragraph. Learned AGA appearing for the respondent submits it is the constitutional duty of the writ courts to protect the public property, and when the petitioner himself admits that he is in unauthorized occupation of the same, he cannot be shown any leniency at the hands of this court, whatever be his representation. First, this is the correct position of law. First off, in the above circumstances, petition is rejected.
No, I permitted withdrawal. I am not the occupant. My forefather is the occupant.
We have told you now. This is our order.
I permitted withdrawal.
We have passed it. Yeah. We have passed it. Yeah. You should have told it before. At this length of time, petitioner seeks leave of the court to withdraw the petition. First off, as a special case, petition is permitted to be withdrawn. First off, registry shall send copies of this order to the OPs by speed post immediately. Okay.
Yeah, I am not occupant. My forefather is occupant of the.
We can't, your forefather is not here. You are here. I have to pass order only against you.
My representation is only disposed of economic law. That is my
property. Tomorrow, this land to be left to the progeny. You are an unauthorized, you are a robber of the public property. How do you protect the robber?
But there is a law, my lord.
There is a law. This is also part of. Yes.
The OPLE law is there, my lord. It's a Prevention of Land Acquisition Act.
Will not pass that. Yes, the red courts are not meant for bad people. This is what Ambedkar ji said in the Constituent Assembly debates. Red courts are meant for scrupulous people. Yes. Dismissed.
Item 23.
23. May please, Your Lordship.
Yes.
When a petitioner who is the ex-Panchayat Samiti member and a vice chairman made a representation to the collector that the OP number 3 and 4 in shifting the concrete drying platform facing from plot number 1 plot has allotted. Thereafter, they violation of the circular, they change the plot, my lord.
Have you given any representation?
My lord, Annexure 4 is a
Let them consider the representation.
My lord.
Petitioner has scripted his prayer as at next paragraph. Learned counsel for the petitioner draws attention of the court to his client's representation dated 25/2/2025, a copy whereof avails at annexure 4, wherein a grievance has been raised in relation to which the prayer is scripted. First of all. Next paragraph. Learned AGA, on request appearing for the respondents, fairly agrees that he would instruct his client to look into the grievance of the petitioner, as has been aired in the subject representation, within a period of 8 weeks, if all contentions are kept open. First of all. This petitioner is agreeable. Counsel for the petitioner is agreeable. First of all. Next paragraph. With the above observations, petition is disposed of. All contentions are kept open. It is open to the answering respondents to solicit signs. Petition, a copy of the order, web copy. To print that, this will mean everything. Everybody should act upon the web copy. There need not be certificate. The petition itself is in web. Why certified copy? That will take another 6 months. Yes.
Item 24.
What is that? 24. To close the subject. Go to the prayer. He wants to close the sub-jail and leave all criminals outside. Where should the criminals be placed then?
24. Petitioner is not there, of course.
Petitioner is not there, but how can this relief be granted? Passover. Send a telephone call to counsel for the petitioner to come and argue how this petition is, where jail should be constructed, where school should be constructed. These are the matters of public policy where court cannot interfere. Yes.
Item 25.
Already issue already decided in the case of Saroj Chandra Parida and Hemant Kumar Chuturai case.
These matters are posted to 3rd week of September.
Issue emergent notice. Call in 3rd week of September. When similar matters are posted. Any WP number?
26 also same.
No, any WP number?
Yes, my lord, the WPC number.
No, not that. Where I have issued notice.
Yes, ma'am.
I have issued notice. You have number? You don't have number. All right. 26 also same.
26 also same.
Call along. Yes.
28, 27.
It's urgent.
That's absolute topics. 28.
May I please?
Yes.
My lord, here the petitioner was appointed as assistant teacher in the year 2010. As per the notification of the government, he should have been regularized after completion of 6 years of service. But
They have not done that.
Oh, no, that is when my lord, he was working in the 2017. Even that period was past, he was not regularized. One FIR was lodged against him involving the alleged offence under section 354A IPC and section 8 of POCSO Act.
354, outraging the modesty of a woman.
That FIR was lodged.
What happened to that criminal case?
That criminal case is acquittal.
Acquittal. You were removed from the service?
No.
You were continued in the service?
No, he was not allowed to continue because after the FIR was lodged, he was transferred to another school. So in another school, he was not allowed to continue. Thereafter, he moved the authorities time and again. No action was taken. Challenging that action, the petitioner filed a writ petition, original application before the Lord's Tribunal. However, that was disposed of by the Hon'Ble Court to consider his case. That was not considered. So in the meantime, the criminal case, he has been acquitted. Now, my lord, he has moved the authorities under to the collector.
Saying that I am acquitted in criminal case, so I take me back.
For re-engagement.
Any D was instituted against him?
No department.
You consider that representation?
Annex 10.
Yes, sir. Perfect. Be seated. Petitioner who was disengaged from serving as an assistant teacher on the ground that he was
not disengaged. He has not been allowed to continue.
This is a disengagement only. No termination order was passed.
No termination.
No termination.
No.
The allegation is refusal.
When you joined the service,
I joined in.
Sit down and answer. This is not a primary school. This is a court where members of the bar are equally important, more important than the judges.
Well, I joined in service on 1st of February 2010.
What is that criminal case?
Criminal case in the year 2017. That is the FIR was lodged on 17/5/2017.
Crime number?
That is
6 of 2017. GR case number 43 of 2016. It is available at page 32.
GR case number?
Yes.
Case number?
GR case number.
FIR case number is 6 of 2017. Dated 16/1/2017.
GR is
43 of 2016.
16 can go.
It cannot be 16.
This will be 17.
That is city case number 4 of 2017. That is there the order of acquittal.
What you call it as?
City case number.
City case.
City case.
Means?
Criminal trial.
Criminal trial. Nomenclature is being changed whenever it is put to trial.
That after taking cognizance.
Yes, exactly.
Yes.
Right.
And the date of acquittal is 28/1/2025.
Is it honorable acquittal number?
Honorable acquittal.
Dated?
Dated 28 January 2025.
Right now. Please be seated. Petitioner joined the service of respondent school as assistant teacher with effect from 1/2/2010. First time. An FIR dated FIR number 6 of 2017 came to be lodged under section 354 capital A of IPC, read with the provisions of POCSO Act. First term. In the light of that, he was not permitted to serve in the school concerned. First off. Thereafter, the police filed the final report under section 173(8) of then CRPC in CT case number 43 of 2017. And after the trial, petitioner gained acquittal with order dated 28/1/2025. First off, he made a representation seeking his re-engagement in the light of acquittal order. Annexer?
Annexer 10 million.
Annexer, the representation?
Yes.
At Annexer 10.
It's dated 6/2025.
Dated 6/9/2025.
9/6.
Huh?
9/6.
9/6/25. 6/9 is yet to come. Next paragraph. Learned counsel for the petitioner submits that because of the ill fate, his client was falsely implicated in a criminal case, and now he having emerged victorious, there should be no objection whatsoever for the re-engagement of his service in terms of his representation. First off. Next paragraph. Learned AGA appearing for the respondents, having resisted the petition, contending that the acquittal is not honorable acquittal, now agrees to instruct his clients to look into the grievance of the petitioner as has been aired in the subject representation. First off, this is fair and reasonable. First off, counsel agreeable with this proposal. First off. Next off, in the above circumstances, petition is disposed of. Time for compliance is 8 weeks, which would include informing result of such consideration to the petitioner. First off, all contentions are kept open. Next paragraph. It is open to solicit, etc. Next.
Item 29. Direct the number 2 to consider the opposite panel 2. Okay.
Why let all them consider or cause it to be considered so that you can proceed against the contempt in all of them. Yes.
That is pending before the OP number 2.
It is duty of all of you. Consider, cause to be considered. Yes.
Item 49.
May I please, Your Lordship?
Yes.
Because the petitioner being agreed to the order under Annex 11 has moved this Honorable Court praying for quashing of the same on various grounds. Because the issue involved in this case has already been decided by this Honorable Court, Divisional Bench, and those judgments have been annexed on Annex 9 series. This petitioner being similar to the cases of those petitioners made representation to the authority seeking consideration of our case in the terms of those judgments. And that having not been considered, the petitioner moved the Honorable Court and the Honorable Court on being directed the opinion number 1 to take a decision on her representation.
Now taken again.
They have taken decision, but they have rejected.
You take notice. Let us
notice. But fact remains, it is my duty to intimate. These two judgments, state is preferred appeal, which has been well intimated in the order itself in page 92. Let notice be issued. These two judgments, they are in appeal.
Any stay is there?
No stay in that.
No, details, sir. It was fixed to 5/8. 5/8. Let notice be issued, then.
Let us call this matter after 5/8. Suppose if they are stayed.
In similar matters, in my case also, in 3 to 4 cases, 3 cases, your Lordship has already noticed it.
Maybe that I did not notice this.
In one case, they have gone to Supreme Court after implementing the order. In another case, they have not carried out the order. They are saying we are government is thinking of going to Supreme Court. Two judgments, one judgment is rendered that is already implemented, and belatedly they have gone to Supreme Court without any stay order.
All right, you take notice then, because other matters I have issued. His client may mistake him. Why not in this case?
Let notice be.
Notice. Learned AGA Mohanty is requested to accept notice for the respondent. Call this matter in the second week of October. Along with which is that matter? Along with
These matters, my lord. Who matter? Only matter.
You should have the number. Now, when you say similar matters, what is meant by similar matters?
Well, I will give you that number.
Call along with, don't fix that. Call along with the WP number. So much. Those who say
yes,
similar matter, they have to put some material before the court to say similarity.
You're not saying I can say. But the second one is also similar to this.
30 is also
29 and 30.
Yes.
Item 32.
My lord, the petitioners are the parents and guardians of the student. Earlier, my lord, the DAV published poll, Jharsuguda, opposite party
What is
member.
that order 16824?
My lord, that is the order passed by the learned commissioner, school and mass education, pursuant to direction of this honorable court, to address the issue regarding hike of fees for 30 times in a single year. And the honorable
that fee was passed fixed in which 30 years ago?
When
it was fixed?
Fixed in 1920.
1920?
My lord, in the year of for the year 2019 and academic year of 2019 and 20.
1919, I was thinking of Jallianwala Bagh massacre.
Sorry. Yes. My lord, it was enhanced to 200 rupees to 6,000 rupees. And the learned commissioner, my lord, kindly see page 33.
What he said?
He said, my lord, that is unreasonable and exorbitant. After hearing both the parties. Page 32, bottom 2 paragraph.
It's a government school?
DAV public.
DAV.
Private school?
Yes.
Private school?
DAV, throughout India, there are branches. Dayananda Anglo-Vedic DAV school. They have their own management also.
How we
my lord, to the resolution of a government that is 23rd November, September 2000.
No, which law?
My lord,
completed my question.
My lord, there is
you
a
don't
resolution
want to ask the question?
Yes, my lord, the private institutions. Sorry, my lord.
Kindly know the question of the court. Can I ask a question to you?
My lord.
You permit me to ask the question? Yes. Which law regulates fixation of fees in private school?
My lord, so far as fixation of fees is concerned, my lord, it is the procedure the school management school authority in consultation with the parents and guardians association. My lord, that is the resolution adopted by the school and formulated by the government of Odisha, which is quoted in earlier decision of this honorable court. I have
read that. Does it refer to any rule?
Yes, it's a resolution passed by the government of Odisha School and Mass Education Department regarding grant of recognition, affiliation, and control over the school, my lord.
Okay.
So far as fees matter is concerned,
he has a key.
My lord, kindly.
1 second. You have to look at the judge also.
Yes.
You are not looking at.
In clause 4, my lord. Sir.
I am issuing notice now. You have objection?
No, my lord.
You have no objection. See, Tagore said in Gitanjali, where the head is held high and mind is without fear, and where the knowledge is free, unto that land, O my Lord, lead my countrymen. Knowledge is free, completely it cannot be free, we understand, because expenditure and other things are there. But you cannot fix exorbitant fee because the right to education is a constitutional right. You are also party here.
We have been added as 1 and 2, but the prime parties are 3, 4, and 5.
Not by party. You have passed one particular order. Why did you not implement it?
Yes.
Close those schools. If they are not agreeable to your order, unless they challenge your order and get it set aside, they are not bound to charge in such a way. You know, education is not a business. See that TMA Pai versus State of Karnataka. Education is not a business. Why you did not implement this order? Why poor people should do? Education, knowledge should be free, means Tagore's that is meant by that only. Otherwise, there is no meaning at all. We have to read the great works of great people of this country into our law. And then it becomes the law of the people.
But out of the way, nowadays, the medical and education, now it became a business.
Anyway, it has become business.
Day in and day out, we all are suffering.
That's true. But at least in schools, that should not happen. In TMFI, they have given some autonomy to the private schools, it's true. But where there is a resolution of the state, that will permit you to have your schools on our lands, will give you permission, authorization, subject to condition that your fees should be reasonable. And you have passed an order. Better school lobby is coming in the way of implementation of this order. It appears that way. Lobbies work sometimes. When that order was passed?
The order, the government passed order 16 October 2024.
22?
24.
24? Issue emergent notice. Now our admissions are over now.
Admission over.
Right? Now full payment is paid.
Areas are outstanding.
Outstanding.
They are taking drastic steps, threatening to withhold the result and not issue progress report.
When results will come? That will be March, April.
Present year,
normally March, April.
March, April. Issue emergent notice, returnable within 2 weeks. First off, matter to be treated as urgent in as much as it has trappings of right to education and therefore abnormal fees cannot be fixed arbitrarily. First off, Mr. Mohanty accepts notice for the respondent 1 and 2, emergent notice to other respondents.
3, 4 and 5.
Other 4 pieces. Call this matter on 20th, immediately after service. Okay.
But in IN not to take any coercive action, my lord.
But in the meanwhile, the application supported by the affidavit is favored and the schools are restrained from taking any coercive action only on the ground that the outstanding fees are not paid as yet. Come on, till next date of hearing. Most immediately after service.
Item 33.
Over matter, similar matter, your lordship has no matter, pass or interim order.
Interim order is passed. What is that matter?
Commuted pension manner. They have deducted manner. Similar manner also coordinate bench manner of this Hon'Ble has passed order.
What is that order? It has passed.
Page 18 man.
19.
18 man.
18.
An extra 3 series.
Issue emergent notice. First one. Learned counsel appearing for the submits that case of the petitioner is substantially similar to the one in WP number 25294 of 2024 between Kalyani Das versus State and others, wherein a coordinate bench of this court, while interim order has been dated 10/12/2024, has issued the reprieve, and therefore the same should be extended to his client on the principle of fairness. First one. Next part. In the above circumstances, issue notice and interim order as in the subject case, Mr. ASC on request accepts notice for the respondents. First, call this matter along with the coordinate case.
I am for 1, 2, and 3. Notice to go for 4. 4 is the bank matter.
1, 2, 3 ASC. Emergent notice to 4.
Item 34.
Ah, 34.
The petitioner has appointed under the rehabilitation assistance scheme. Lordship has issued notice last week.
Similar matters we have issued.
Yes.
Issue emergent notice. Learned ASC.
1 to 3.
1 to 3.
Only 1. Number 4.
Notice to 4.
Only to 4 is registered routine.
Emergent notice to 4 by speed post. Returnable within 2 weeks. Call this matter along with WP number.
WP number 21,302 by 25.
21,302 up to 2020.
Yes, it is to second week of September.
Anyway, it will come along with that.
Item 35.
Yes, sister.
It is second round litigation, my lord. Our next 8 is my rejection order challenge. Similar order passed, my lord.
Similar matters are
Yes, ma'am. Yes.
Issue notice. Learned ASC accepts notice for OPs. Any private party?
No, ma'am.
All OP.
Yes, ma'am.
Call this matter along with WP number. You write down a small chit you can pass on. Yes.
Item 36.
In this case, my grievance is pending before OP number 5.
What is that grievance?
My lord, the block authority is trying to construct a road, village road, over my ancestral property, which has been recorded in name of my father. I have made objection and prayed to the BDO not to construct the village road over my land.
Property.
My lord.
But you should file a suit for injunction.
My lord, maybe my lord, but my representation is pending before OP number 5. That may be considered, and the demarcation shall be made, and after demarcation they may be construct the road.
Petitioner is knocking at the doors of writ court with the following prayer. Next paragraph. Learned counsel for the petitioner submits that the property right having been constitutionally guaranteed under Article 300, the representation made by his client at an exile, dated
11/7/2025.
Representation dated 11/7/2025 at an exile A2, wherein the grievance is aired, needs to be considered by
BDO, OP number 5.
OP number 5 BDO. First, he adds that the consideration having not taken place, this court should come to aid of his client. First. Learned ASC on request appearing for the OPs opposes the petition, contending that disputed fetch matrix is involved, and therefore petitioner should be relegated to civil court. First off, having so contended, now he agrees to instruct his client to look into the grievance of his petitioner, grievance of the petitioner as has been aired in the subject representation in accordance with law, if all conditions are kept open. First off, with this proposal, counsel for the petitioner is agreeable. First off. Next one, in the above circumstances, the petition is disposed of. Time for compliance is 6 weeks. First, all contentions are kept open. Next paragraph, it is open to solicit. Okay.
Item 37.
On behalf of Mr. Patnaik, my lord, Passover.
Passover, what did this matter? No, you don't know, man. You are a proxy counsel.
My lord, mine item is 13, that's why.
Okay. Okay. Just to give that, let us see. Some temple money is diverted.
My lord,
That may not be permissible. Take notice.
Yes, madam.
Issue emergent notice. The ASC accepts notice for all respondents.
Yes, madam, for all the respondents.
Go please. Call after 4 weeks. Yes.
My lord.
Item 38.
My lord, may I please,
Yeah.
my lord, in this case, my lord, the villagers are filed the representation before opposite party number 5, my lord. What happened in this case, my lord?
What representation?
My lord, what happened in this case, my lord? My lord, one is the boundary of the village, my lord. My lord, one row is passed over in the middle of the village, my lord. But unfortunately, my lord, the nearest village people are coming here and put a board in they remove the government board, my lord. They put a board in his own village name, my lord. That is the problem, my lord.
They are calling your village with their village's name.
My lord. My lord. My lord, the road is going to the middle of the village, my lord. And the government board also, my lord, kindly have a glance the photographs.
You gave the representation.
My lord, my lord.
That representation is not considered.
My lord. My lord, the
photographs.
Annexure 5, my lord. Annexure page 4, my lord. Annexure 4, page number 15, my lord.
They want to call your village as their village.
My lord.
Name.
My lord. My lord, the photographs, my lord.
What is the name of village?
My lord, Ustapura, my lord.
Ustapura.
My lord.
And their village name is?
Their village name is, my lord. My lord. Uttapala.
You consider representation?
My lord. My lord.
Okay. This is a curious case, wherein the petitioners are weaving against non-consideration of their representation in relation to the alleged unauthorized naming of their village by the neighboring villagers by putting boards on the road that interjects the village. First of all, next paragraph. Learned ASC on request having accepted the respondents agrees to instruct his clients to look into the grievance of the petitioner as has been aired in the representation dated 2/4/2025, a copy whereof awaits at Annexure Airport. First off, representations of the kind have to be met their fate at the earliest so that the same should not lead to avoidable difficulty to the villagers. First off, next paragraph. In the above circumstances and with the above observation, petition is disposed of, fixing a period of 6 weeks for taking the decision in the matter with the participation of all the concerned. Okay. Deeply obliged, my lord. It is open to solicit information from the petitioner or from any other department. Okay.
Deeply obliged, my lord.
Web copy.
Item 39.
May I please, your lordship?
Yes.
My lord, the claim of the present petitioner in the writ petition is for sanction of MSCP, that is Modified Assured Career Progression Benefits, my lords.
Very similar matter we treated, brother. Similar matters we treated. Take notice.
So here is a case, my lord. My lord, I was approved for the granting aid, but the full granting aid from the year 1988.
Even if you argue more, I cannot allow the petition without notice.
No, I have approached the authorities because there has been amendment to the earlier resolution of 2017, my lord. By virtue of the amendment which came into force in 2024, they have extended taking into consideration the initial date of appointment when I got the minimum granting aid for the purpose of counting 10 years period.
But we will issue notice.
My lords.
Not necessary. Notice not necessary.
No, my lord. Since I have already approached the authorities, I was praying that let the authorities take a decision there on, my lord.
On the representation.
My lord, that is pending, my lord.
Yes, brother, what is
Yes, my lord. Yes.
to take decision on the representation?
My lords.
Petitioner is invoking writ jurisdiction of this court with the prayer scripted as under. Next up. Learned counsel for the petitioner submits that even before coming to this court, a representation dated
my lord, 21/6/2024.
21/6/2024 has been filed with the jurisdictional authority, namely
the Regional Director of Education, Barampur.
OP number
3, my lord.
OP number 3. And no decision is taken, nor there is a hope that any such decision would be taken in the near future. And therefore, this court should come to the aid of his clients. There is force in this submission. Next paragraph. Learned AGA on ASC accepted notice for the rest of OPs, fairly agrees to instruct his clients to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law, should all contentions be kept open. First off. He also agrees that the consideration would happen within an outer limit of 8 weeks. First off. With this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition code of fixing a period of 8 weeks for compliance. All contentions kept open. It is open to solicit. No more.
This case, my lord. Direction to resubmit the pension paper, my lord. Similar matter you lordship disposed of.
We should dispose of or should?
Dispose of, my lord.
Saying what?
My lord? Saying only annex of 3 instead of 4, man. And date of appointment is 91. I have corrected.
You have corrected. As it is, it should be printed now. All. Print this all. Dispose of. ASC for the respondents.
Item 41.
I only request not to mislead me because I believe you. I fully believe the members of the bar. There is no reason to doubt because I have not found any one person lying before me. Maybe wrong things may be said honestly, but nobody is lying before me. That's a great thing. I have great respect for the members of the bar. I told it to my friends at Bangalore that they never mislead the courts. They will say what it is and slowly fight whatever order we will pass. Therefore, again, I request you, do not mislead me. You can't mislead me also that easily. Yes. Yes.
One item, the petitioner limited grievance made a repeated series of repetition to OP number 1, 2 regarding the handed over the school hostel. It was constructed and annexer to 2019.
By whom?
By the government.
Government constructed it.
Constructed and that was keeping with the government. Till under annexer 2, he made a circular. My school name is serial number 10.
They should give the hostel to your school. What is your right?
Because it is handed over in the government in year back 2012.
School.
It was your land.
No, it is the school land.
It is school land.
School land. That is annexer 1.
1 second. It is a school land.
School land.
Full stop. Then that land you give to government.
Government
for putting up
construction of school boys hostel.
Where is that understanding that after construction we will give it to you back?
Under annexer 2, page 11, serial number 10.
for UP school in Kitimiri.
100-seat boys hostel, Netaji HS at Chinnasari. My school name is
Chinnasari.
Chinnasari.
They have constructed the hostel.
That was constructed by the government. Till yet, they have not handed over me.
Why, brother?
Because I made a series of representation.
Why are you not handing over?
I will take it first, my lord.
Want something?
No, my lord. A tribal school, my lord. It is constructed from.
No, all these things happen nowadays. I know what is happening. It's not that I'm just closing my eyes and sitting in my chamber. I have my informants.
The office of the collector, my lord, they are directly.
Some vyavahar takes place. Vyavahar or avyavahar. Issue notice, emergent notice. Learned ASC on request accepts notice for the OPs.
All the opposite parties.
All OPs call this matter on 20th. On 20th, you can't retain. Having built the hostel, if you open the goats will enter them.
My lord, for their purpose, it has been constructed.
That's what.
What is it?
You come out with the proposal from the government. I will ask why that has not been. After construction,
Yes,
why have you kept it vacant? What for? The goats will enter.
The construction itself meaningless, my lord.
That's what. You say all that to me, but tell it to your clients.
That the certificate Lord Superior directed me on the other occasion, my lord.
Yes.
That has been.
Tell them, threaten them that I will take stringent action. I will not just leave them. I am not happy with the government, the way the government is run, with the way the employees are treated. 700 kilometers transferring teachers without any reason, rhyme, as if they are your captive slaves. And contract teachers. What kind of contract teachers? What kind of teaching they will do if they are taken on contract? If their tenure is not assured? Everything done objectionable.
Item
Yeah.
42.
No, in this case, it is really praying for early disposal of the miscertificate appeal. Case number 1 of 2024.
Miscertificate appeal, what is that case about?
That case about my lord.
Miscellaneous certificate, that is issuance of my lordship fund. That is a residential certificate.
Residential certificate.
It was issued and subsequently it was torn down by the authority, Tahsildar, the authority who is issued the.
No appeal is filed.
Yes.
That is kept pending since more than a year.
Yeah, more than a year.
Because petitioner's innocuous and short prayer is scripted as under. Next paragraph. Learned counsel for the petitioner submits that right to speedy disposal extends, speedy justice extends to the proceedings before the quasi-judicial authorities also. And therefore, miscellaneous certificate appeal case number 1 of 2024 needs to be tried and disposed of on a war foot, regard being had to the implications which a person having no certificate of the kind would face. First of all, there is force in these submissions. Next paragraph. Learned ASC on request appearing for the respondents, although initially resisted the petition, saying that the authorities have other duties as well in addition to treating appeals of the kind, now agrees to instruct the official respondents to dispose of the subject appeal within a period of 3 months.
3 months.
First off, this is absolutely fair. First off, next paragraph. In the above circumstances and with the above observations, petition is disposed of. The concerned authority to, or the OP number 3 to dispose of the subject appeal within a period of 3 months and report compliance to the Registrar General of this court on contingencies. No cause.
Item 43.
The petitioner has prayed to grant revised arrear salary and a current salary. Similar coordinate bench has passed the order, my lord.
Passed the order?
Yes, ma'am.
Covered by the judgment?
Yes.
What do you say?
I will give
Show copy.
Copy.
You have changed
Change code.
entire order now.
I have changed.
Is it not contempt of the court?
Xerox.
It's covered by judgment, brother. I have disposed of similar matter.
Police.
Yes, appears for this. Okay.
Item 44.
Petitioner is a class 4 employee. Regulation of service. Earlier he approached this honorable court. This honorable court allowed his prayer and which has been confirmed by Honorable Supreme Court. Thereafter, under Annexure 7, the authority regularized the service of the petitioner from the date of office order, that is on 10th June.
Will be with retrospective effect.
Yes. A similar matter, the Lordship issue notice.
Emergent notice.
Emergency notice
Yes.
to 1 and 2.
Yes, for 1 and 2.
Yes.
And private party?
No, my lord. Other at government.
1 and 2 notice has to go.
Yes.
Issue emergent notice to respondent numbers 1 and 2.
Similar.
Other OPs are represented by alternate ASC. First of call this matter with WP number.
Item number 47, 49 also same.
47, 49. Call along with each other. Yes.
Item 45.
And just one password.
Password? Yes. What is this matter about? Let's see. At least by 12 or 15, all admission matters should be over so that I can take main matters.
Only one password. Matter related to the appointment of Hon'Ble worker only. Sorry, Shiksha Sahak appointment. As for the decision of, as for the advertisement under Annexure 1, that was challenged before the Hon'Ble single judge, thereafter that was
that decided and remained.
That was challenged before the division bench writ appeal manner, and the appointment, my appointment was rejected under Annexure 4. Annexure 3. There is no 30.
Then what is?
36.
Take notice.
No, my lord.
You have sought for
No, my lord.
Subsequently,
No, my lord.
let me say.
Your lordship may kindly see page 14 of the writ application.
Subsequently, I was also given appointment, but
my lord. First, he was appointed as Shiksha Sahaka. He refused to join, my lord.
Let it be Pasona, otherwise my senior will.
We'll have it some other day. Today not possible. Call week after next. That's the question. Yes.
Item 46.
6 million feelings. Challenging the order dated 28/3/2024, the Annexure 7.
What is that?
By the Assistant Provident Commissioner for Hon'Ble, directing the petitioner's college to deposit Miller the limit rupees 11 lakhs the employer share as well as the employee share. Correct. And according to the direction of the Assistant Commissioner Miller, the present the petitioner's college have already deposited out of 11 lakhs 911 is deposited paragraph 9 page 6 your lordship can see. I have deposited 8 lakhs 96,082 rupees.
3 lakh
outstanding is 2 lakh 11,030. And that the employee share is rupees 1 lakh 5,540. In spite of the direction of the Higher Education Secretary as well as the petitioner's college, he is not depositing his share.
He is not contributing his share.
No, that is the problem. The lordship kindly see
8.33%.
My lord,
That is the rate of
kindly see the letter under Annexure 8 Miller. The government of Orissa, Higher Education Department, petition was made by the opposite party number 3 before the higher education, since they are not depositing the employer share, but the lordship kindly see, this is the letter
was requested for depositing the employee share in the earliest in order to enable for settlement of EPF pension and other benefit by the concerned college and EPF authority.
Employer's contribution is paid.
Yes, that is not disputed. Our share, the husband's share is not paying because his husband already died since 2021. That was that is from the
when the copy is out. So I usually appealing for the PF department. We shall show that I can take instruction.
Learned Panel Council Shri. Accept for notice for
one.
Which respondent?
1 and 2.
1 and 2. No other respondents.
Other 3 is the private.
Emergent notice to 3. But don't take any coercive action. He has already shown bona fide.
I have filed
Any entry model?
Yes, I have filed when I not to take any police.
No coercive action to be taken pursuant to impugned order till next date of hearing, since petitioner has shown bona fide by paying that part which lies on his shoulder. On its shoulder. Therefore, he said no coercive action against you.
That may be mentioned that
pursuant to impugned order dated
28/3/2024.
28/3/2024.
Under Annexure 7.
At Annexure 7.
But 2 copies. 2 copies of the representation.
You give 2 copies. You give him 3 copies. He will be happy. 2 copy and 1 copy. Yes. Yes.
Yes, sir. 7 is connected with 44, sir.
Connected with 44. Perfect.
Item 48.
May I please, Your Lordship?
Yes, sister.
The second round litigation, my lord.
Similar matter.
Similar, 35.
Yeah, issue emergent notice. Learned ASC accepts notice for copies for this matter. Any private party?
48, 45, 48, my lord.
Private party is there?
48, my lord.
No, private party.
No private party.
No private party.
No private party.
Call along with WP number. So
49 also conveyed to Item 50.
Yes, sir.
Here the petitioner is continuing as a data entry operator in the university since 2004. Last 21 years, she is continuing. And he has questioned the Annexure 11, rejecting the prayer.
How many years?
21 years, since 2004.
Issue emergent notice.
The university authority, the government is 1, 2 is government.
1, 2, 3.
No, 1, 2 is government.
1, 2.
And 3, 4, 5 is university authorities.
Emergent notice 2, 3 and 4.
3, 4, 5.
3, 4, 5.
They are university authorities. And I also pay for IMLS.
Not to terminate you.
Not to take in, yes, not to terminate.
They
have continuing.
Continuing. The petitioner shall be continued in service as usual till next date of hearing.
Item 51. Item 51.
51. What's the prayer?
RSCP, madam.
Issue emergent notice. ASC appears for respondents. All respondents.
Yes.
Call this matter along with WP number. Any WP, connected WP? Just looking.
No, all or not all responded, madam. Only 1 and 2, madam.
1 and 2.
Madam.
Emergent notice to the rest. Document. Call along with some WPs are there? No?
Yes, madam.
That's just take number and yes.
Item 52.
Item 52, may I please, Your Lordship?
Yes, sister.
Your Lordship, this is regarding the payment of the area of the demonstrators, Your Lordship.
Similar matters we are considering. Which is that?
On Friday, Your Lordship was pleased to issue notice in a similar matter, Your Lordship.
We have number of that case.
Yes, Your Lordship. WPC 21845 of 25.
Police. WP 21845 of 2025. All respondents ASC. Any private respondent?
Opposite party number 5, Your Lordship, is the principal of the college.
Emergent notice to OT5. Call Avanti. Yes.
Obliged, Your Lordship.
Item 53.
The transfer matter representation is pending.
You consider the representation and till then don't give effect to the transfer order.
No.
The short grievance of the petitioner is as to non-consideration of his representation dated 4/8/2025, wherein he has sought for retention of his service in the same place. First one. Next paragraph. Learned counsel for the petitioner, pressing into service the decision of Apex Court in Varadara versus State of Karnataka, submits that non-consideration of representation or delayed consideration would be fouled by the courts, and therefore interference of this court is warranted. Next paragraph. Learned DAC appearing for the respondent, having resisted the petition, contended that the petitioner is in a transferable job and therefore he has to honor the transfer order. First, having so contended, now he fairly agrees to instruct his clients to look into the grievance of the petitioner as has been aired in the subject representation dated 4/8/2025 at Annexure 6 in a time-bound way, if all contentions are kept open. This is reasonable. Next one. In the above circumstances, petition is disposed of. And till consideration of subject representation happens, and if the result is informed to the petitioner, he shall be continued in the same institution wherein he was hitherto working. It is open to solicit. Right. So a copy to be acted upon. No court. Yeah.
Item 54.
54. 51. Where we should notice. Where we should notice.
Non-representation.
Heard is restrained.
Appearing on VC for item of 53 and 54, Your Lord.
53 and 50. What is this matter about?
You know, this matter is supposed to be conducted by my senior.
Which you should notice in your absence. You have to clear the fee with me now. You have to give 50% of fee to me.
Consider representation.
54. 54 also consider representation.
Yes.
What is that representation? Give that.
Representation at Annex 7.
For? What is your representation, brother?
The transfer order with 53 and 54 both are transferred to each other in case of each other. With regard to that.
Same. 54 also transfer order. Same order. Which we have just the dates and other things. Just get. All right. Okay. Yes.
What particular is it here?
Item 55.
I think to submit. Here in this case, my lord, coordinated bench has directed for an inquiry by the learned secretary of the department. Into the because these base of cases related to one institution, there is some allegation of fraud. I guess the person goes a visit.
But when there is a senior advocate, the practice is
no, he sorry, he asked me to submit. I was there.
His case is actually One of the first case.
No, my case, everybody's case. Are you same case? Yes.
Most of them. Thank you. Achha.
So,
Just a minute.
So now I don't.
Just Mr. Rathas.
One minute. Just a minute. People may not print starts. The order dated 21st of March 2025. Bench.
21st January
24 of 2012. First case, sir.
Legal heirs to be substituted. Legal heirs to be brought on record.
Sir,
has been brought on record.
Sir, everything has been done. But just, Mr. Rath, please. Well, actually, look to that FAO number 548 of 2000. That is there. You have come up with that.
Whether you have brought on the
630, yes.
You have brought on record.
Yes,
One
format B. Because
answer my question. Whether LRs are brought on record. Yes.
No.
No,
Has not been
the court in your matter, they might not have amended.
That is the matter.
Yes, no, they are saying, let us
34 of 2012, where the orders, first case, where the judicial order has been passed that allowed to be brought on record, they are not on record.
Let us see the paper.
Sir, may I be permitted for a moment, sir?
Whether
Yes, sir, yes.
on record or not can be ascertained by looking to the paper.
Yes.
234 of
234 of 2012, this case number 310 of 2013.
One second.
yes.
Yes, they have already amended the petition. But they have not told you that was.
Sir, I will permit it. Sir, this was also published in the local newspaper. And after publication, they have appeared in the connected case. Those legal representatives, they have appeared in the connected cases. That was verified by the coordinate bench.
What happens is, you should have given copy of this amended petition to your friend also, so that he would have. They have not
Given it, but I will subject to. That is not an issue.
Anyway, they have brought on record.
Yes.
You share that first amended the copy of the first page, second page, or some page.
That's that will be no issue at all.
That is not all.
If they have brought on record, notice by not.
Huh? No.
You were also appeared.
This has gone, they have appeared.
They are not just in this case they have to be noticed. But if the notice to the
After notice only they have been brought on record.
Yes, that's on record, sir. Sir,
This is a paper notification.
Sir,
Notification.
please.
Can your lordship have a look to the notice given item number right for motion?
The senior
Lord counsel for RAE, representation number both of cases they are not brought on.
And
yes.
That order subsequently it has been placed before a coordinate bench, and the coordinate bench said that matter will be taken up. And if you also will see that FAO number 637, which Mr. Das was saying, in that bench, application, they have filed an application for modification. You also look to that.
Maybe permit.
No, I have not applied for modification. No, please. I have not applied for modification.
Shall I place it in 2 to 3 lines so that if my lord will permit me only that month? What happened? As I have stated, there was some allegation, counter allegation between the parties. It is related to one institution. Granted, has been paid to some person. Those who are minor, those who are not qualified, and all these things. A direction was given by this Hon'Ble Court way back in 2010 in a particular writ petition 2463 of 2010 for an inquiry. An inquiry, perfunctory inquiry was conducted. That is why, my lord, in this, the coordinate bench has directed on 7/3/2025 to that is in, my lord, that my lord will get it, that order in 637 of 11. FAO number 637 of 11. My lord will get it.
Order dated.
Why so many years these matters are pending?
Yes, that is, my lord. What happened? This Hon'Ble Court has directed. Thereafter,
litigations for one.
That is the proper time, my lord.
Mr. Das, please don't interrupt.
Start.
Yes.
In that particular case, my lord, just I am telling the dates, my lord, because I remember something. If it will be confronted, I will show the records. So on 7/3/2025,
In that, what is the gist of the matter?
Yes,
Yes.
If uninterrupted submission, my lord, if I will be permitted, then I will submit
Let
it.
them
Yes,
say whatever they want.
Yes.
Don't worry, I will hear it.
yes, sir, that much, my lord. What happened, my lord? This is the institution name is.
I will hear you also.
Yes.
I will not pass any order. without any-
I will narrate the entire story within minutes or two. My lord, Santilata Mahavidyalaya Vitikri, it was established in the 1980 with the educational agency headed by one Shatrughan Jena. These are the relevant, that is why I am making the mention of the name.
1980.
80. One Shatrughan Jena was the founder secretary. Under our Odisha education. Shatrughan Jena. J-E-N-A. Jena, man. He is there now. So, as under the Odisha Education Act and the rules framed there, the provision is an agency or the group of persons. They have to establish, who has established the institution, they will also constitute the governing body. Till then, they will function. So, therefore, this agency headed by Shatrughan Jena and other members, they establish the institution and manage the institution. A RIP came out when this institution, the governing body was not constituted.
It's a private institution. Even now it is a private.
No. It now became added. That is history, my lord. Just I am telling because.
1 second. It was a private institution. Private, unaided.
Unaided. Recognized, unaided.
When it became aided?
Aided, my lord, with effect from 1/6/88. See, when this institution was eligible to receive some gratuity from the government, the RIP started between these employees, management, and all these things.
When it started?
To become eligible to receive gratuity from the government. At that point, all these disputes started.
Eligible or after it was admitted?
No, only eligible. Only because the first is there is the dispute. So what happened? A group of teachers, those are now the opposite party here, they managed to send a proposal. I am using this word, there is some manipulation of records. And that proposal was with the government. Some writ petitions were filed. The proposal was pending with the government for approval of the staffs. Writ petitions were filed. Even that Shatrughan Jena also filed by his personal capacity, not as the governing body. Some another Ravindra Jena
after aid.
No, before this aid, all these disputes starts. So what happened? Well, this matter continued. A order was passed by this Hon'Ble Court directing the director to cause an inquiry.
Inquiry into what?
Inquiry into the staff position, institution, what is the functioning, all these things. That was there was a direction of this Hon'Ble Court. And the director went to cause an inquiry. In fact, the director has not gone. He has sent somebody else. Deputy director and additional director, all these persons, they had been to that place. This governing body they noticed and they didn't turn up to participate in the process of inquiry. What happened? Basing on the document produced by those teachers in their favor, they have submitted a report that these are the varied staff.
This was when you had sought for approval to the staff pattern.
Mine.
That was
in sometime, the inquiry was in sometime in 89. Gratuity was in fact paid in 99. In fact, the payment was made in 99, madam. I'm just seriatim I'm placing.
That's all right. The report of the inquiry dated?
That was on 24/6/1989. The first report. I will give it because I thought that will go to the other banks.
Dated?
24/6/1989.
Whose report it is?
That was the director's report, madam.
Director of Public
Education.
Higher Education.
Madam. Initially, my lord, it was public instruction. Thereafter, it was bifurcated through the department. That's no issue.
Yes. Then what?
So that report, here's the names.
Your friends can go for a coffee round, perhaps. It appears this matter will take some time. Others can have a coffee round and come back.
Subject to my lord friend's verification, but he wants to bring to Lordship's notice, and it is your duty also to bring to Lordship's notice. In fact, an order has been passed by a coordinate bench. They have application for modification of that order. If that directed for inquiry, you have filed an application to recall that order.
Inquiry is going on.
This inquiry was pursuant to
In order.
bench order.
Yes. Then this interruption,
Now,
please,
there-
please,
one second, Mr.
please,
Das. One second, Mr. Das.
Arey, what?
No, my application for modification, they are saying
I'm
that
saying anything.
address my lords. Mr. Rautra says that we applied for modification and recall, which is not a fact. But can we consider why? Not, that is not correct. Not what is the issue?
Yes.
WP, that direction to hold inquiry was given in which WP? WP order?
That was in
WP number?
that was in this year. E49 etc. No, it was the recent order was in FAO number. Recent order, my lord. 637 of 2011 in FAO, not WP7. The batch of cases.
FAO order dated
7/3/2025, 2025. But what I was talking about those report of 1989, because I was placing the facts and saying my senior. Yes, recent, because earlier I was saying this in the seriatim I was placing. As my lord senior is saying here, to consult the issue, my lord, there was an order. Just I'm coming to his point, my senior Mr. Rautrai's points. There was an inquiry in 1989. Without giving the details, date, my lord, I have to go through record. So 89, there was a report. Basing on that report, my lord, in 99, initially 5 teaching and non-teaching staff were approved and they were paid gratuity with effect from 1/6/1988. Though it is in 99, order was on 27/2/99, approval order.
27/2/99. That the grantee need order or approval to the staff.
The employees, 5 employees. Yes. But it was given effect from 1/6/1988. Retrospective.
Do you have the date chart with you?
No, that date chart I have to prepare. What happened, my lord? Because I was in the impression, because my coordinate bench, because all these states, my lord, was heard by a coordinate bench of this Hon'Ble Court before my lord taken up. On 7/3/2011, my lord have directed, 25, my lord have directed that let a fresh inquiry, because looking into all the demands and counter demands, directed the directors, government should call, secretary shall cause an inquiry. In fact, all the parties appear before the secretary, who also appear before the secretary. And it is on. But only 4 dates has done. At that point of time, my learned friend's client move a IA. This IA number 548 of 25 with a prayer, my lord, that inquiry should be kept in abeyance. That is why.
On what ground?
My lord, ground that earlier completed. So no, this inquiry is not required.
Where is that order for inquiry?
Well, 7/3/25, that my lord will get it on FAO number 637 of 11. Third case in the room. Can you see very present? 637 FAO 637.
So that inquiry was conducted without notice to other side?
No,
Yes,
yes,
the order.
That's not,
the commissioner comes cause an inquiry, and that inquiry is on. Both the parties appear. All the parties appear on different dates.
The report to be submitted on 25 or before 25/4/2020.
Yes, that's not for time, my lord. The commissioner has asked for time. The Hon'Ble Court has allowed them some time. Thereafter it is on, my lord. Last week it is also there. He has posted the date is not given, inquiry is on. They have appeared. After appearing,
They means who?
Opposite parties. My Lord friend appearing.
Mr. Rath's clients also.
There is many advocates.
Lordship will hear me. Your Lordship will.
At that juncture, this IA was filed, IA number 548 of 25 in that particular FAO.
IA number
58.
Go to 548.
548 of 25. That will be at flag 25.
Filed by
my Lord friend's client.
let us say because his application.
Yes. Just I'm saying, yes. What just I'm completing the report. Now, what is the prayer there? Essentially, I have understood from that.
No, he has not argued.
No. I'm just reading out the prayer. I'm not saying anything against it. I am saying what is the prayer. The petitioner there.
So Mr. Rath need not read his prayer at all.
I don't mind. But what happened, my Lord? If the misunderstanding of this IA is, if that order will be altered or this order will be require some modification, the coordinate bench is there. They was in the help of it was hard different. If my Lord will hear it, then I will place with a dead chart. I will come up and place it and enter.
Or other want to take the matter away. That's not the objective. Yes, like allow me to submit. Now you have completed. Allow me to submit. Now, Lord, your Lordship, with my Lord's kind permission, this institution was established in 1980, got recognition in 1982. But I have given a small compilation of this for assistance of us.
I am filing an objection to that IA because we have just heard the copy and taken on record. I am giving a copy.
I am asking one question.
Yes, I'm just the mail can be taken on record.
They will not permit me to say, Lord. I know that.
I will permit you. Don't worry.
Yes.
I will permit you.
Yes.
But before that, permit me to put one question.
Yes.
Now, an order is passed by a coordinate bench of this course. That order you want to modify?
No, Lord. I don't want modification.
You don't want modification?
No. That is the whole misrepresentation going on. I don't want. Today, what is the position, my Lord? Lordship, kindly see my compilation of documents.
Let us go to your IA. What is your prayer?
Yes, ma'am. Kindly see. I say that what is not before your Lordship, not one, just two sentences. What is the case your Lordship hearing? Kindly see that FAO. What is the case your Lordship is hearing? Kindly see. 1 second, Mr. Rautrai. Please see. Kindly see, my Lord. They are not permitting, my Lord. This is not this discipline of the court. This is not a discipline of the court.
He will also. I will hear you also.
Yes, I will.
My whole objective is not to allow me to start.
There is no person, but there is no chair to sit. I am standing there. There is no problem.
But kindly see.
I am not disturbing you.
Yes, Mr.
Kindly see FAO 637 of 2011. This is the case Mr. Das is arguing.
Of 2011.
Yes, 637 of 2011. This is the case being argued by Mr. Das. What is this case?
No, I was not.
1 second, Mr. Das, please allow me to submit.
I was not the counsel there. There is a group of cases. I was one of the counsel in other cases.
But kindly appreciate, my Lord. Kindly maintain discipline, my Lord. It's not expected.
Yes.
But 637 of 2011.
Sometimes, Mr. Rath, I have learned a great lesson.
Yesterday we have heard your Lordship, my Lord, in the meeting. We are really enlightened. I was so impressed. But my Lord has not come. I have seen through YouTube. I have heard your Lordship through YouTube. You are starting from Ramayana to Mahabharata.
Is it necessary that one should go? One can
say your Lordship pitch.
All we have to go. One fine day.
And I can prepare your Lordship speech. I have heard through YouTube. Educative was that. But the different matter, my Lord. Kindly see FAO 637 of 2011. Kindly see. What is this case he is arguing? This is the case of one single clerk who claimed granting aid from the government and whose case was dismissed by Education Tribunal under Section 24B. 24B is the power of the Education Tribunal to decide the dispute as to entitlement receiving granting. Now, this particular person approached the tribunal, look, I am entitled to GIA. Please sanction GIA in my favor. He is a clerk. It's a service dispute. Its tentacles cannot go beyond the individual cause of action. Now, today, this person challenging the order passed by the Education Tribunal by which tribunal rejected his claim before my lords in this appeal.
On what ground it is rejected?
It is rejected because this person is not a genuine staff. This person is an imposter. There are 4 inquiries taken place. There are 3 writ petitions dismissed, challenging those inquiries in this honorable court, confirming the report. There are 4 inquiries, 2 by government, 2 by orders of this honorable court. Those inquiries are upheld in the writ petition. They challenge the inquiries in this writ petition, in this honorable court. Those writ petitions have been dismissed to the effect those inquiry reports in favor of these 5 employees are upheld up to this honorable court by virtue of which they got the grantee. Now today, in your FAO, where you are the singular person, you are asking to reopen inquiry as to every staff of the college as if it's a PIL. As if it's a PIL, kindly consider, my lord. Now what I am trying to demonstrate before my lord is those inquiries, orders passed by this honorable court, entire thing in a convenience compilation I have given to my lords.
Where is that?
I have given that compilation. Kindly see that compilation. Now, my lordship, straightway come to page 11 of my compilation.
No, my lord friends, going out of the
I didn't hear you. Others who are here.
This case is concerned.
Kindly see.
Now he's
submission kind of disturbance created.
Out, Mr. Roth.
Not south.
It's a question. Let's try and ask the question that what is the prayer made in this case?
Sir, I will hear you also.
So, sir, because he's going away from the issue case, and now he has come up with a merit of the case.
My lords, it's not merit. Only in this case, I want to say this.
And we are ready, sir.
This is not the way to stop a council from submitting.
Wait, please. Allow him to complete.
Senior counsel is there on the complete, sir.
But your lordship asked the question, if I'm correct, that what is your case?
Now going to the aspects. Besides entire thing.
That will place.
Starting every judgment, I will place the fraud, the manner they have played before this honorable court.
You told me to hold.
But I am just taking your lordship to page 11. Kindly see.
Which is that page? You want me to look into? Perhaps it appears of mics to be kept silent.
But they objected to disturb me. That's all.
No,
Kindly, one second.
Yeah.
My lords, kindly see. Lord, as I said, my lords, after the college become eligible to receive grant in it, the then principal in charge submitted a list of employees that these are the persons who are eligible to receive. Now, that list was challenged by the Jana in this honorable founder, secretary, the then secretary. That is, I'm sorry, Shatrugana Jana's brother, Rabindra Jana. He is also a member of the governing body. Now, 347 of 1989 is the writ petition filed by him challenging that recommendation by the principal in charge. Now, kindly see the order passed in that writ petition, page 11. I'm sorry, Lord. That is running page 5 of my compilation. Thanks. Running page 5 of my compilation, order passed on 2029. Now, this order was passed. Kindly see. After hearing the learned counsel for both the parties, there seems to be a little controversy about the genuineness of the staff pattern submitted by OP number 3. It is alleged on behalf of the petitioner that many eligible persons have been omitted from the list of submitted OP number 3, that the other persons have been wrongly shown. It is ultimately agreed that in order to avoid any conflict or controversy between the parties, the propriety of the staff pattern may be examined by the Director of Higher Education, and that grantee may be disbursed by him directly to the employee entitled to receive the same, and we accordingly direct. We hope and trust the OP number 1. Complete this exercise, carry out direction within 1 month also. After this order, the director conducted an inquiry. Your lordship may kindly turn to, straightway come to page 11 instead of taking all these lengthy inquiry report. Kindly see page 11, man. Well, finding starts from page 10 of my compilation. Circumstantial evidence indicated that staff of this
This is the report of
Director of Higher Education, pursuant to the order passed by this Honorable Court.
They have kept one knife also here. I do not know what. This is the report.
This is the report.
What the report says?
Said, Milord, kindly see page 10. Circumstantial evidence indicated that staff of this college have not been actually paid their salary, though they have been forced to sign the accountant's roll and as evidence report from payment of salary and regularly. This has happened in case of initiation terrorism adopted by the secretary of that Shatrughan and his brother, this petitioner. Terrorism of his brother, who is a member of the GB and affluent and influential person of the village. The members of the teaching and non-teaching staff of the college have suffered for no fault of theirs, but due to high-handed action of secretary of the GB, that's Shatrughan, the inquiry revealed that secretary tried to remove the members of the teaching and non-teaching staff illegally and arbitrarily with malefied intention or malefied from college, and there is a reason for which trouble started and continuing in this college. Now, regular GB of the college shall be constituted as early as possible. Till a regular GB is formed, none of the members of the existing teaching, non-teaching staff should be removed from the college. Members of the staff, as per list given below, whose appointment, order, joining report, qualifications, so have been verified by the deputy director, non-college, and are due to receive granting aid from the staff part, if otherwise found eligible, as per the existing granting aid principle. Now, who are the five? Number one, Nutunja Pohar. I am asking about these persons. 3, lecturer in Odia, Jatindra Das, lecturer political science, then Godadhar Sahu, clerk, then Godadhar Sahu, clerk, then peon, Ravindra Parik, then Chakradhar Jena, serial number 6 of this list, my lord. Now, after this inquiry report was submitted by the college, your lordship will see that that entire this was challenged. This inquiry report was challenged before this honorable court. But in Notice 880 of 91, lordship would kindly see page 24 of my compilation. Who challenged this? We are Shatrughan Jena, who is reported to be a dangerous person. That's yes, Shatrughan Jena, page 24, challenged that report in this honorable court. Now, what came out here? Kindly turn to paragraph 11 and 12.
In OJC 880 of
91. Kindly turn to page 11 and 12, man. The inquiry report was challenged here. Kindly see page 34, capital A. The above extracts from inquiry report clearly indicate that persistent efforts are being made by some parties to prevent disbursement of granting aid. The intention seems obvious that the staff have been deprived of by some vested interest for obtaining benefit.
Where are you reading?
I'm so sorry, my lord. I'm so sorry. Internal page 11, page 34A, para 11.
34A.
I'm so sorry.
The above extracts from the
report clearly indicate that the persistent efforts are being made by some parties to prevent disbursement of granting aid. The contention seems obvious that the staff have been deprived of by some vested interest from obtaining benefit of granting aid, which they consider as their right. Para 12. We have given the matter our anxious consideration and are of the view that relief cannot be granted to the petitioner. In compliance of the order passed by this court, in earlier writ petition, an inquiry was conducted by the director, who is the responsible officer in the education department. The inquiry report indicates that all possible efforts were made by the director to notice and hear all who appear to be in some manner or other connected with the dispute. Members of the staff, Sarpanch and headmaster of another institute were heard. But neither the petitioner nor his brother Rabindranath Jena appeared in spite of repeated notice, and even though Mr. A.K. Roy, the deputy director, had personally approached the petitioner and tried to persuade him to participate in the inquiry, request was also made to the members of the governing body and villagers to attend the inquiry and to make statements if they so desire. The fact that a magistrate and police had her requisition give an indication of atmosphere which was prevailing at that point of time. As the petitioner failed to participate in the inquiry, in spite of notice and personal request, he cannot now raise the grievance that he was not heard in the inquiry. If he wanted to say anything, it was open to him to appear before the director to put forward his grievance and plead his. Having not done so, he cannot raise any objection. As stated above, the director is a responsible officer, and there seems no reason for us to doubt his bona fide in conducting the inquiry. The fact that inquiry was being conducted was, it seems, to known to all. This is also evident from the number of persons who appeared before the director. Therefore, we refuse to believe that petitioner was not aware of the inquiry. Moreover, apart from making general allegation, there is nothing on record to indicate the director had stated in biased or partial manner, as no material has been placed before us by the petitioner to show that director had an interest in favor of persons approved against the petitioner. Allegation that director acted in a partial manner cannot be accepted. Now, after this judgment, granting it was released in favor of these 5 persons for whom
what happened to the civil suit which he had?
Yes. One civil suit was filed that was also discussed in the judgment, and kindly see that I am also placing
the interim order of the civil.
There is, I believe there is.
What happened to this?
Those were not prosecuted by the concerned persons who had plaintiffs that filed.
And it was dismissed.
Yes.
On which?
Sometime in 99.
Has to be given, huh?
No, I'll give that date. But for the present, my lords may kindly again turn to page 38 of this compilation. Kindly turn to page 38. But your lordship was asking about the date of approval and release of granting. This is 27th of February 1999.
So this case came to be dismissed by the bench.
Yes, Lord. Challenging that inquiry by the Director of Higher Education, meaning thereby upholding the inquiry. The Director's inquiry report was expressly challenged in this petition by Shatrughan Jana.
That challenge failed.
And consequent upon that inquiry, which was otherwise accepted in para 11, 12, 13 of the judgment, Division Bench judgment of this Hon'Ble Court, the approval orders were issued, that is at page 38. Kindly see.
This is approval for the staff pattern.
Yes, ma'am.
In terms of the recommendation of the inquiry.
Absolutely correct. So grateful. So grateful. Page 38, my lords, may kindly see. This is 27th of February 1999. And the names.
Approval of the force.
Yes.
With the Director Higher Education.
But it is by the government. Secretary.
No, approval was granted by the Deputy Secretary to government.
But it is by order of the government, by order of the Lordship will see the High Court numbers were referred to here also in the order itself.
Okay.
The first writ petition, second writ petition, those 2 writ petitions are referred to here also. OJC 347 of 89, wherein the direction for
80 of 91.
88, but that where the inquiry was challenged. Just I read that judgment.
Miscellaneous case 51296.
But that is arising out of that OJC, but it's not no for disbursement of salary.
Okay.
Now this is the approval order of 1999. And today the position, I'll take further your lordship, Lord.
Yeah.
After this approval was passed, benefits were disbursed. Lord, at the behest of that very Shatrughan Jana who lost the case here in this Hon'Ble Court.
In favor of?
Beg pardon? Yeah. The miscase petitioners.
These petitioners?
The miscase petitioners. The whom I am pleading. Now my name, I am giving those names. Lord Mrityunjay Puhan.
Who were not recommended, who were recommended.
Recommended. And favorably reported by the inquiry committee. Directly.
Yes.
Now, after this disbursement was made, the same Shatrughan Jana would somehow or other manage the government for a fresh inquiry. I said, there are 4 inquiries. Now, by this time, the second inquiry at the instance of, after dismissal of the writ petition, after approval order, Shatrughan Jana again managed to hold an inquiry before the government about validity of these staffs. Page 45, my lords may kindly turn to. Page 45. One second. But at the level of government, another inquiry took place. Your Lordship will see from page 45 the relevant portion. In the above facts, page 45. In the above facts,
the college is
receiving grantinate with effect from 1688. Sri Das lecture political science, senior most teacher, was approved by principal in charge of the village so-and-so college. The person claiming to be original staff of the college and disturbing the so-and-so government are actually not employees of the college as per so-and-so in the directorate. Hence, as per records available in the directorate. Hence, the question of releasing a grantinate in their favor doesn't arise. Report submitted by the then Director Higher Education dated 24/7 that one which I placed here was not based on relevant official records. After sanction of grantinate, the collector was appointed as president of the governing body by the so-and-so. Accordingly, collector has submitted a proposal for constitution of the governing body Santilata so-and-so, which is pending at directorate level. This should be disposed of immediately as per the order passed by the government in OGC number 37 of 97 to avoid contempt. Now you kindly page 41A. Page 41A. Yes, but just before that, Lord Lakshmi, kindly take the pen of flipping over to page 41A.
Yes,
but this is after that inquiry report again by at the level of the government. Please refer to your due letter number so-and-so dated so-and-so on subject noted above. I am to furnish here with a detailed report regarding sanction of GIO in favor of staff Santilata Mahavidyalaya as desired by the government. Since the grantinate was sanctioned in favor of valid staff of Santilata so-and-so as per the verdict of High Court and government order, question of regular and irregular staff of the college at this point of time doesn't arise, hence chapter may be closed. So at the level of government, again this inquiry and this order in the year 2001.
This was sent by whom to whom?
It is by the government, Lord. It is by the director. It is by the additional secretary to the government to the director. Let me see from at the bottom there additional secretary to whom it was addressed is to the director.
From director to additional.
No, director sent it to additional secretary.
Additional secretary, right. I'm so grateful. Now,
saying that no inquiry is required because everything is looked into and collector has attained finally.
Another inquiry in the level of the government. Then on the basis of that, saying that no further it should be closed. It should be closed.
Another inquiry was held.
Yes, page 42. Detailed report regarding sanction of GIA in favor of Santilata Mahavidyalaya. Kindly see page 42 of my compilation, and I placed on the concluding part. Should I read page 44 onwards? Yes, sir. Last part clear is. This is 3/9/2001. 3/9/2001, page 44, the concluding part of the report. Again, I may take the risk of repeating again, madam.
3/9/2001.
Right, madam. Your Lordship will find the
bottom.
Yes.
What they said.
Page 44. Further, the government has been pleased to approve the following different posts of Santilata so-and-so for sanction of grantinate by GO number 27/2/99. These are the staff which have placed 5 out of this.
Recommended by the earlier inquiry report.
Yes.
Same names.
There is no difference. Government have also sanctioned
funds.
Yes, government have also sanctioned funds for payment of grantinate to the above employees 6,86,000 by letter accordingly. Approval order was issued by letter number so-and-so in favor of the staff of Santilata in order to comply the orders of the Hon'Ble High Court in WPC, so OCRMC 136 of 97 arising out of 8880 of 91. In the above facts, college is receiving grant in aid with effect from 1688. Sri Das, lecturer of political science, the senior most teacher, was approved by principal in charge of the college by our so-and-so dated 7/3/99. Person claiming to be original staff of the college and disturbing the government are actually not employees of the college as per records available in the directorate. This is the case of those persons, my lord. Directorate. Hence, question of releasing in their granting it in their favor doesn't arise. Report submitted by the Director Higher Education by letter dated 24/7/2001 was not based on official records. After sanction of granting it, the collector was appointed as president of the so-and-so college by Director so-and-so. Accordingly, collector has submitted a proposal for constitution of the governing body of Santilata Mahavidyalaya, which is pending at directorate level. This should be disposed of immediately order of the High Court in OJC 371 of 97 to avoid contempt. Now, this by virtue of this inquiry, the order page 40 on A was passed.
Mr. Ratha is not hungry now.
Beg pardon?
Are you not hungry now?
He's hungry. Yes, decided. Lord,
They'll come afterwards. Post lunch we'll continue.
So good.
But today it should be completed.
Yes,
one level.
Yes.
But 1 minute, sir. Because you also is hungry, we are also hungry. But so far the right to begin is concerned.
Yeah, I am hungry. You are.
No, I am not hungry, sir. We are not hungry at all, sir. But the right to begin, we also keep it in mind, particularly in such type of cases, the petitioner or the appellants. So once we try to make an attempt to bring to your lordship's notice some orders, now my learned friend pounced upon it and he is now taken away the right of the right of. Please, Mr. Rasan, let us start your lordship. Allow the list to start.
If you want to.
Yes.
All right, we'll do that. He has seen what is
He has already completed with 5 minutes to complete. No, why? Sir, let me.
5 minutes will.
Yes, sir, it's not a question of 5 minutes. Yes, sir.
Are you launching satellite?
Right, sir. It's not a question, sir. Right? Yes. Allow me to complete. He wants to somehow.
I want to hear it today. But the difficulty we may face is because this is the I only consider for consideration it was there.
No, you're
that is why we are ready.
No. You should be ready.
I'm submitting.
11, 14 years have elapsed.
Yes, my lord. If you wanted to hear it fully and finally, then we have to place it in a ruling. Whatever the document we have, we will place. So that we will have a right to start. That is my senior is saying.
You have to do it today.
Yes, we are ready.
So great. No problem.
Happy, my lord. Just about to complete.
You're praying for your lordship's indulgence.
Pastor matter. Just I'll complete. I'll complete just 2 pastor matters.
Right.
Just complete them.
May I pray for your lordship's indulgence? This is a very urgent matter regarding 57 class 3 and class 4 employees who are likely to be unseated day after tomorrow. Can it be taken up tomorrow?
Take it tomorrow.
Great for us. Great.
The least matter will continue. The other matter will not. My matter is.
How do you suppose if it breaks?
No. So my matter is 87. I am not getting salary.
Don't worry, you will not damage your man.
No, I is there. I think next locksmith call any other day. In the orders hearing.
Let it be. I will not damage any of the matters. With that assurance, you can go home.
No.
Or you can sit also.
No, I can sit.
No, I need not wait because it may not reach also.
It may not reach. But I can next week. Let us see. Orders.
That we don't know.
Okay, IA is there.
Let us see.
My lord, Passover matter, item 24.
24. 15 is there, no? 1-5. Yes, what is that matter about?
Your lordship may kindly see the last order dated 15/7/2025. In that order, your lordship, the Hon'Ble Court was pleased to direct the State Council to produce the dismissal order.
Who should produce it?
My lordship.
Yes, brother.
Your lordship called this letter.
They are not obeying the orders.
Letter might have been shoot. The file is not here.
Huh?
File not produced.
File not available.
Yes, well.
Whether it is available in your office or it has gone. Other day I was reading a story where a complaint was lodged saying that some goods have been stolen. Then the complaint was lost. The police asked him to file a complaint against loss of a complaint. Same things are happening in our government now. We'll call this matter next week. Just
next week.
Matter. 2 weeks. Learned government, learned AGA assures compliance of the order dated 15/7/2025 made by a coordinate bench of this court. First, on that assurance, matter is adjourned by 2 weeks. Item 44.
Item 44.
Tomorrow we have difficulty, na? Calendar will fall down with the weight. We'll have it week after next.
No, I will put the order number 59, my lord. Repudiated filed immediately accepted.
59?
59, my lord.
It has not reached yet, sir.
Not yet reached.
Yes, sir.
No,
not yet reached.
No, order.
Let us wait. Yes.
So, Lord, I was at page 45 of my compilation. I was showing your lordship the inquiry taken up so much at the behest of this Shatrughan Jana, page 45. I was just concluding that.
You needed 5 more minutes and they readily agreed also.
Exactly 5 more minutes. Not. But page 45, my lords may kindly see. But I have already shown that.
Yeah.
I have already shown that it's an inquiry taken up at the behest of Shatrughan Jana by the government, and government dropped it, having found that appointments are genuine and those staffs are new. Now, thereafter, this is in 2001. But this is in 2001. So 9 years thereafter, these people are, I am though appearing for the governing body, I am here for the governing body. These employees, those who have been reported to be genuine staffs, 2010, 9 years thereafter, that very Shatrughan Jana again filed an application before the government, and government withheld the grantinate of those employees. Again, 2010, government withheld grantinate of those approved staff which have been approved by the government consequent upon 2 inquiries. Am I clear, my lord?
So you filed the WP number?
Those employees, they filed WPC before this Honorable Court 2463 of 2010.
What's the code?
Yes, Lord. Kindly turn to page 49 of my compilation.
In view of the aforesaid fact, we have no hesitation to quash the letter by which it was halted.
Beg pardon.
Letter which halted the release of the funds.
The withholding of approval, withholding of grantinate was quashed by this Honorable Court, because in 2010, at the behest of again the same secretary, ex-secretary Shatrughan Jana, those approved staffs grantinate were withheld. Same ground of again fictitious staff, yes, those things were there. So grantinate was withheld in 2010. Say they challenged that holding for this Honorable Court. This Honorable Court passed orders of 2 parts. One, withholding of grantinate was set aside, relying upon those earlier inquiries. Again, this Honorable Court directed for a fresh inquiry. Kindly see that, Lord.
Fresh inquiry?
Yes, page fresh inquiry, page 49.
Yes, I read that.
By the government, would said that in conclude.
Kindly see, Lord, page 49.
Yes, I read that.
They kindly see, in view of the aforesaid fact, we have no hesitation to quash the letter dated 1.
That is quashed and a fresh inquiry is ordered.
But the entire exercise shall be completed within a period of 1 month from the date of communication of this order. Status quo and rate shall be maintained till a decision is taken. Now, after this order, kindly see page 50. The commissioner concluded the inquiry again at page 50. Pursuant to the direction given by this Honorable Court, just I have read, man.
Yes.
But it is only 2 pages. Kindly see page 50. pursuant to order dated 16/3/2010 passed by the Honorable High Court, writ petition number so-and-so, Santilata so-and-so, on verification of record, second paragraph, on verification of record, it reveals that on 28/1/2010, an advocate on behalf of Founder Society so-and-so submitted an allegation petition before the Commissioner cum Secretary against two teaching and 3 non-teaching staff of the said college who are receiving grant in aid from the government with effect from 1/6/1988 fraudulently and by manipulating records, and requested to stop the grant in aid by grant in aid being given to these employees. Commissioner cum Secretary passed orders to hold up the grant in aid and these employees till date of hearing, and Director Higher Education was intimated to stop grant in aid of the following staff. These are the staffs we have placed earlier, Milord, by those very same names. Against this order, Commissioner Secretary agreed by employees filed writ petition number so-and-so. While disposing of the said writ petition, the Honorable High Court, by order dated 16/3/2010, passed order that the Commissioner cum Secretary to Government Higher Education Department directed to conduct inquiry, peruse the records, where the parties so-and-so and the Joint Secretary directed the decision as to whether the petitioners are entitled to receive grant in aid, and thereafter pass orders, necessary orders, strictly in accordance with law, the entire excess so-and-so. In the orders of the Honorable High Court 2463/2010, it has been directed by the department that 1/2/2010 withholding of GIA Jatindra Das so-and-so.
Wait completely and come to that outcome of review petition.
Right. Right. Accordingly, it has been quashed by the High Court so-and-so. In view of the above, during hearing from the both sides, it is observed that petitioner Jatindra Das and others have been functioning. So while the opposite party Ratikanta Panda could not satisfy his stand or disprove the stand of Sri Jatindra Das and others on the contrary, thus it is hereby ordered that in view of the order dated so-and-so, the withholding of salary so-and-so degree of Joint Secretary Government so to be released subject to outcome of review petition and other that exercise. Right, ma'am. Right.
Which is that review petition?
That review was made because of the fact that the order had twofold. One is that at one hand the order was quashing.
But to that again inquiry is ordered.
No, that is not that was not called in question. The only part which was called in question in the review is that status quo, because of which the salary could not be released. But thereafter, when this proceeding was dropped, we drew the review and salary were.
Now, this right. But this report by the government at page 51, again has been challenged in this honorable court, that is WPC 13708 of 2012 by one Ratikanta Panda, no?
That is posted today.
That is posted today.
This is by whom?
He is an imposter to the institution. Everybody is being set up. Everyone is being set up. Ratikanta Jana, this petition is pending. That is at page 53.
Who is he? He is a lecturer.
No, he is not a lecturer. Yes, I am so sorry. I beg apology, Milord. I beg apology. I am extremely sorry, Milord. Page 53, lecturer in political science. He claims to be lecturer in political science, but he is not reported to be the lecturer. He has not been approved.
Was he ever appointed?
That is the point. He has never been appointed. He has never received grant in aid. His services were never approved, but he claims to be lecturer in political science. Government has rejected his case.
Government rejected his case for what?
That he is not eligible. He is not a genuine staff of the college.
Which is that order?
This is that.
Forms part of that order of duty.
So, go to this. Give it to the honorable court. Give it to the honorable court. Mr. Dori,
sir, we have been injuncted. So therefore, we have.
It's not injuncted. I'm finishing it, sir. It's fine. No, I'm not. See, he is showing that order to your lordship. That order will be shown to your lordship. But it is at this stage. Now, your lordship is considering what is that proceeding? That is FAO. This is that FAO 637 of 2011.
That is
Lord, what is that FAO? Yes. What is that FAO? Let them argue, Lord. Now, it is at this stage what I am humbly contending that your lordship has seen the inquiries, the reports, report has been once confirmed by this Honorable Court, even
There
of
were
this.
multiple reports, court said it's all right.
Right, Lord.
No case for interference.
Right. Now, to my IA, what I'm saying is, any action tinkering with those reports or even a fresh inquiry would amount to in the teeth of the division bench order passed by this Honorable Court, wherein the earlier inquiry is upheld. In that case, my lord, I will be citing Manohar Lal. Your lordship is aware about that judgment. AIR 2010 Supreme Court 2210, Tara 23, 24 and 25. And Soran Singh 96 Supreme Court. Lordships are aware of those judgments. My lord, that says any action contrary to the court's direction is a nullity in the eye of law. Like it is at this stage, what are you doing?
What is that prayer in the IA?
IA is at least to not to hold inquiries so far as these persons whose inquiries have attained finality.
Read your prayer.
Praise that Lordship SCC please to allow this petition direct to segregate inquiry initiated by order dated so-and-so, keeping in abeyance inquiry relating to petitioner number so-and-so, pending final adjudication so in view of the order dated 7/8/2012 during the earlier orders. I say that these persons who have been conclusively inquiring into, their inquiry is upheld by the bench. You cannot reopen it by virtue of a proceeding involving two adversarial parties. That is one person claiming peon and it's not a PIL. You cannot reopen the whole thing, other teachers, non-teaching staff, political science, their eligibility, their ineligibility, those are otherwise they have to be made parties here. They are not before my lords. You are taking orders to hold an inquiry in respect of their genuinity of their service, which have been conclusively filed in the division bench of this Honorable Court. That's what my humble contention is.
Well, let us see
Grateful.
what the problem is.
Lordship, once we told I can add Lordship before Lordship, not senior starts Lordship. And Lordship was just wanting to see Lordship the order of rejection of this Ratikant Panda Lordship. Lordship, that is available at running by 48, Annex A by 4 Lordship, to the counter Lordship.
48.
48 Lordship. No, 108 Lordship.
What the order says.
Lordship, kindly.
Just tell what the order.
Lordship, I'm reading Lordship, the entire Lordship. Pursuant to the Honorable Court, the opposition number such and such Ratikant Panda was state of Orissa and others, the claim of Ratikant Panda lectured in political science of Santilata Mahavidyalaya Uttukiri in the district of Baleshwar relating to the approval of his appointment and sanction of granted head has been duly examined. Dr. Santila Jana, Secretary of Santi Mahavidyalaya, submitted the proposal in the Form A of granted order 1994, in which the name of the petitioner finds place against the post of lecturer in political science. Government, after careful consideration, have been pleased to decide that since Dr. Santilata Jana has not been notified as the secretary of the approved governing body, as proposal submitted by her has not secretary sanctioned and as such cannot be considered for sanction of granted. Hence, the claim of the petitioner for approval of his appointment and sanction of granted is rejected. So that, and Lordship, only another thing, Lordship, kindly see.
You appear for whom?
Yes, I am for in this particular case, Lordship, I am asking for the governing body, Lordship.
Respondent.
Lordship, respondent, Lordship.
But allow the petitioners to argue.
But Lordship, only one thing, Lordship. Only supplement, Lordship, what my Lord senior submitted. Lordship, just Lordship, kindly see order dated 7, 8 or 12. For moment, Lordship. 7, 8 or 12. In particular, the application, Lordship. There is a judicial order
saying,
Lordship, kindly to release all those matters, Lordship, to take it independently. Because every case has independent cause of action, Lordship. And Lordship, kindly see order dated 7.
All right, we'll take them. Don't worry.
Lordship,
still you want to argue?
No, Lordship. Just I want to, Lordship.
Sir. So before I start, sir, I must give thanks to Lordship, at least Lordship. Now, Lord, I will start. In fact, I am appearing in the first case in the review application. But since these matters have been tagged together, and Your Lordship, the controversy started because of the order dated 7/3/2025. You also look to that order.
7/3/25.
Yes, sir. In episode number 637 of 2011. In batch of cases. All the cases have been referred to and let's get it. Order number 25. Sir. Sorry.
637. 637.
637.
Second sub item रे भी थोड़ा facility.
Well, I'll do it.
You can.
Second survivor will be second. Order is there.
Has to come from registry. Yeah.
Has been passed. The second sub item, FAO number 238/7 your article.
Board package.
Silence.
Order number 25.
You are for the.
You're also referring to FAO 637 to 11.
Subala.
Subala Charan Behra. Yes. Subala Charan Behra.
Charan Behra.
Yes.
CH means Charan.
Yes. Charan. CH means Charan. Chandra, that can also be considered Chandra.
In this, what?
Come to order dated 7/3/2025. 7th March.
This is under section 24C of the Orissa Education.
Yes, sir. There is a provision which was brought
which Mr. Rath.
Yes. No.
I mentioned about section 24.
For which arising out of that appellate suit.
The Orissa Education Act, there was an amendment in 1998 where for the first time it was incorporated all matter relating to granting it in connection with it that will be adjudicated by a tribunal constituted for the said purpose. Earlier, that tribunal was only conferred with the power of hearing the matter under section 10A in the matter of termination. But this power was conferred on the tribunal
by amendment.
And a provision was also added, 24C, against that order of tribunal. The matter can be carried this honorable court in first appeal.
First original appeal.
First appellate of orders. Now you
original FAO means?
FAO means against the order passed under section
first original appeal.
Sir. And there was a judgment here that FAO order could have been challenged before the division bench, but that judgment has been subsequently modified. Record, it was said that no, that FAO only and conclusive subject to. Yes, sir. Kindly come to the order.
In this FAO, what is the status of the petitioner?
So that status of the petition
we call him as appellate. Appeal, na?
It is appellate against the order. Just I'm reading.
Who is he?
Sir,
who is he?
One of the employee of that institution, that particular institution, he is one of the employee.
Where is his appointment order?
Sir, that is there. I'm reading a different way because I will request your worship to take up the matter one after another. But this is the question which your worship have raised and they have answered. I am raising this question first. Now, sir, read this. Kindly, I request your worship to have a glance to this judgment. Hard on counsel appearing for the parties.
Page number?
That is order dated 7/3/2025. I am referring to the order. Order number is 25. Let's get it. I'll take only 5 minutes maximum. You also look to the matter is taken off through hybrid mode. Hard run counsel appearing for the parties in the present batch of matter. All parties also look to the all appeals were listed. Peruse the instruction provided by the department by letter dated 15/5/2024. So produced by the additional standing counsel in court. The same be kept on record. Considering the instruction so provided. And after going through the relevant records so produced earlier before this court, it is found that compliance of the order passed by this court on 16/3/2010 in WPC number 2463 of 2010, though an inquiry was conducted in the chamber of the Commissioner cum Secretary Department of Higher Education, but it is found that prior to conducting such inquiry, order passed by the court on 16/3/2010 has not been followed by issuing notice to all parties to this dispute. Since the report has been prepared without giving opportunity of hearing to all parties concerned, this court is of the view that for compliance of the said order, a fresh inquiry is required to be conducted by the commissioner of the department. 6.
One second. But this runs counter to what the division bench said.
Sir.
This.
No, sir, I will show that order. That division bench order will show that. Sir, yes, sir. Yes, sir, yes. Sir, in view of the same, the court directs the commissioner cum secretary to cause a fresh inquiry by giving opportunity of hearing to all parties before this court in order to avoid delay. The parties before this court in the present batch are permitted to appear through their counsel or in person on 21 March 2025. On their appearance, Commissioner cum Secretary, Department of Higher Education shall fix a date of hearing and all the parties be intimated about the date of such inquiry. On the date of inquiry, respective parties be permitted to file their document in support of their claim, and the Commissioner, after going through all the document and by giving opportunity of hearing to all concerned, shall submit a report to this court. Such report be submitted by 25th April 2005. Now you also look to the application which was submitted, IA number 548 2025, which your worship wanted to know what is the prayer, but I am showing your worship one paragraph of that affidavit. The affidavit was filed by Mr. That's the client. Flat 15. Flat 15. Mr. Rath's client, who was the respondent number 5, respondent 4, he has filed this application. You also look to page 2. That in compliance to the order, let's get it.
Yes.
That in compliance to the order passed on 7/3/2025, the inquiry commenced with notice to concerned parties and the same is in progress. Then the ultimate prayer you have already seen. The petitioner therefore prays that this honorable court may kindly please to allow this petitioner further direct to segregate the inquiry initiated by the order dated so and so by keeping in abeyance the inquiry relating to the petitioner in registry so and so. Not that they say that the order should be recovered, or their case is not that is without jurisdiction or that is contrary to the order passed by the division bench. That division bench order by friend will show. So now the question is, the order was passed in their presence and they participated in the inquiry, and the inquiry was conducted from time to time, and it's continuing. If you also will ask the that what progress they have done, they can say. And in fact, last time they had said that we are moving an application for extension of time because it could not be completed by now. So now at this stage, the respondent number 4, can he say that I am not bound by that and I cannot participate in the inquiry and the inquiry be segregated? That is my point. That is for your lordships to give the proper order will be passed by your lordships. I have nothing to say. I only just bring to your lordship notice. This is the order passed by a coordinate bench.
Come to paragraph 12 of the application.
Yes, sir. That therefore both humbly submitted that this honorable court guesses will please enough to segregate the inquiry initiated by the order dated 7/3/2020 and directed for keeping in abeyance the inquiry relating to the petitioner of WPC number 2463 of 2010 pending final adjudication of 13708 of 2012, which is also before your lordship in the board, wherein they have added as opposite part of portrait. Now your lordship pause for a moment. I request your lordship, this is the genesis of the matter, because inquiry has been directed and inquiry is being conducted, no progress. Now if your lordship, in fact, I thank your lordship that your lordship wants to dispose of the matters for all time to come, because matter is pending.
Because we can't keep them for another time.
Yes, Lord, I agree with your lordship. Because your lordship see the entire order scene, how many times matter has been absorbed and whose instances the order itself will say. That's why I'm not going to those question. Now your lordship come to the first case in the board, the review application. Because my lordship will argue extensively because he is appearing in many cases, but I am appearing in the first review application. I will show your lordship that will show that how the inquiry has been conducted and how the order has been passed. Your lordship. My lordship is saying that so far they are saying that division bench that is contrary to the order of division bench. The two division bench that will be solved. To your lordship. I am in a very limited. I
hear you also.
Sir, I just put a second. There are probably this is weighing in your mind, my lord. Only one division bench that was in the OJC 880 of 91. But there is another division bench for which this inquiry was directed, WPC 2460 of 2010. where they filed that review. My lord was putting that question, what about the review? The review filed by them was dismissed also.
No, by that time review was because the money they ordered status quo. Is what I remember he had said.
What he's saying.
Court had ordered status quo. No money could be paid to anybody. Therefore, we had moved that application.
No, probably that is not correct.
Sir, now kindly come to the first board review application. Yes, sir. My point is very, very limited because I am part of the first sub-item. First list of the sub-item. 1 hour. Review petition number 234 of 2012.
Now, 1 second. Just I want to know the segregation which Mr. Rathore wanted. Segregation. There are too many inquiries. There is actually one inquiry.
The object intention is, if at all there is an inquiry at the behest of one person, that should be confined to the petitioner before my lords. Because it is not a litigation involving other employees before my lord. What is the case about? 24B application seeking granted approval is rejected by the tribunal. Listen, now
therefore, it should be confined to that.
Not only, no, you have never paid for inquiry before the tribunal. You have never paid those inquiry report. That 2010 inquiry report was never challenged before the tribunal. Am I clear, man?
Yes, sir.
Sir, it's a 2.7.
Yes,
Mr. Lord. Sir, so far the inquiry, I'm going to show you, Lordship, so far the inquiry which my learned friend is referring again and again, that is in respect of only confined to 5 persons, those who have approved that I saw from the record itself, sir. That has nothing to do with how it is illegal, how it is absolute fraud has been perpetuated. That is the entire case. Mr. Lata, please.
I am not saying anything.
I'll just clarify.
Yes. So, my lord,
Mr. Roth is saying is with due respect to him, my lord, he want to say hide something. What happened? That report is referring to is 36/1989, the first report, where the director has stated that these are the persons, genuine staff of the institution, which was given a seal by this Hon'Ble Court, another division bench, in OJC number 88091. Thereafter, there is a provision. They have been approved. In the approval orders itself, there is a clause. This approval is subject to
outcome
section. Para 21 of the 90 GI order, granted order 1994. Para 21 of the granted order 1994 says if any concealment of fact, any fraud, any sort of misrepresentation
be liable to be
that is why, my lord, the government has complaints were made. Government on its own wisdom, my lord, inquired into the matter, domestic inquiry they have conducted, and they found that this 5 person against whom the inquiry was directed in 2463. Government in 1/2/2010 passed 2 orders. First, withholding their granted. Second, same date another letter directing for an inquiry. Whether these are the genuine staff. The 5 person were one Jatindra Mohan Das. He was the principal of the college, has got granted. He didn't have the possessive qualification. Minimum eligibility 55%. He didn't have that qualification. Even twice he has attempted, he could not qualify 50%. He has been approved. Moreover, they are appointed by a stranger. All the appointment order can be issued by one Satrughan Jana who admitted to be the secretary of the institution. But one Ramchandra Varik, which is a stranger, he has put a signature and given an approval that has been approved by the government. So second question is, another Mrityunjay Puhan, who was a teacher in another high school at the relevant time, on some Sudarshan Academy, Punjab, that is a school man. He was teacher in that particular institution, but for the same time he has drawn salary as a lecturer of this institution. Another 2 persons, the peons, 2 peons have got the granted, those are minor. Under our service code, there cannot be any condonation of age of a minor. ORS can be condoned under the service code rule 52. But minors have been appointed as they got the granted. No. And when the minor, majority only in 1991. What is the resolution they have shown to the minor? Because this was an inquiry. This is the inquiry. Now say, I got majority in 91, but they have been paid granted from 88. It is not. These are the facts, my lord. That is why government has directed for an inquiry. Against that direction, 2 letters, my lord, they came to this Hon'Ble Court in OJC, WPC 2460/2010. That is a division bench. The division bench had taken note of all this fact and came to a conclusion that because you have stopped their salary arbitrarily, release the salary, but the second letter That inquiry has to, whether they have done all this mischief or not, that is a subject matter of inquiry. The two orders first. The one order was this.
Whether all persons against whom inquiry was sought to be held.
Yes.
Are they all alive or some of
all are alive? They are alive. Some of them are retired. Some person are there.
Some of them are.
Oh, they are alive. They are appearing. They are appearing in the inquiry. Like this. I will be in my duty.
This is very unfortunate. Why you make a solutions?
It is that order, my lord. It is 2463 when the direction was given.
We were taught in the college that the argument should generate light and not the heat.
Yes,
that too in a hot country like hot state.
Because I want to say,
can be a lighter here. This is self-defense of mind. I'm self-defense of mind.
Nothing. I record something. If that will break or a disturber while my lantern, it may break.
No, which matter you are arguing?
No, because these are the entire scenario. What we are arguing is, my lord, that order dated 7/3/25, as my lord senior has said. Because this honorable court, these points were raised before the coordinate bench. Coordinate bench directed for an inquiry. Yes, sir.
Your friend pointed out. There is a judicial order.
Yes.
To hear each of the matters independent of other. There is a judicial order. That order is
That's
analogous hearing. That's right.
Because the 7/3 order will get together. Yes. That order will can see. 7/3/25 order.
In that order, he did not show to me.
The old order. But now latest order 7/3/25. After hearing all these parties, my lord, has directed us.
Yes.
As an inquiry. That is the order, man. That is not.
Sir, may I suggest one thing?
I am asking.
Since your worship may hear all the matters at a time, but one after the other, if your worship will hear one after the other, that one case can cover the 4-5 cases here. So
not all cases.
It's not all cases, but
some cases in process.
Yes.
How many cases are here?
Other cases have not come, has not come to court, man. There are also other cases relating to this dispute.
Very same dispute.
Yes. Because kindly see, my lord, 7th order.
Very thorough. Because he's arguing this matter. So
remember,
matters are in the board.
Here, my lord, 7th order, kindly see. 7th order, the head road.
Head road touch.
All these cases are now before my lord. Others are also there.
7/3/25.
Yes. There are head notes, man. FAO number, that ordering codes. 6/3/36.
All these matters are not here today.
That is,
yes, that is there.
That is there. All are there.
Yes. And one of the such matter is, please take note of matter, WPC 17219 of 2010. This is by these 5 persons against whom the entire allegation now revolve around. That is why my lord have directed. Court has the inquiry.
Long since.
That is closed.
No. It is pending.
Because salary was released, therefore.
It is pending now. Today it is pending. I don't know whether they will withdraw. They will.
Long since.
Then the board.
So you want to withdraw that petition?
Yes. 17219.
1 second. It is today at least one bit. Go to that order. Learned counsel appearing for the petitioner in WPC number 17219 of 2010. Kindly give a memo.
Sir, I have already filed a memo.
That he has already filed a memo seeking leave of the court to dispose it off as having become infectious. First off, ordered accordingly and petition is disposed of. One is over.
Is dismissed as withdrawn.
Yes, but because that has a nexus to this case, man.
Anyway, he wants to withdraw.
That is
How can we prevent?
We cannot prevent.
We cannot.
Right. So now, madam, can you see all these cases?
Let us take 637 first.
No, that is rule. That will be a batch of cases can be disposed of if Madam will hear the review petition first.
No, let me that is the first matter in the board.
My senior is 1, I am in 4.
Oh, give that review.
34.
What's the item?
Sir.
Give that review petition.
Date chart diya to that case for chief case
understood
please you could have said from beginning All the matters have been. But
This was also saying from the very beginning.
the person, those are opposite party here, they have appeared in other connected cases.
They're there in the other connected matters.
Sir, one person died on his PLRs were after
Sir, let me place my case then, sir, because you are so hard.
LRs, there are question of bringing LRs will not arise at all.
No. Because salary, the question of salary, withdrawal of salary and all, everything is there. That fellow has retired in the meantime and he is dead. Because he was made a party.
I also see this.
And you have made him a party. So therefore his legal heirs were
But they were made parties after notice to them.
Yes.
Public notice.
Yes, sir, notification is a public notice in the paper, newspaper.
Thereafter,
they have appeared in other connected cases. My landfriend is appearing for them.
He is appearing for the same.
Not appeared for them. Who prevented it? I don't understand it.
Appearing for the government.
Why you are so much worried to file place my
all they have been served. He would have been served.
Sir, no, not all, sir. You will see the kindly have a look to the cause.
If he has appeared, then how could he say that, sir?
Wait a second. We'll verify that.
Sir.
Cause list we should see now. Where is that cause list? Given the cause list also along with the papers to you or what? No, I have here. Which is this, let us study the cause list now.
My lord,
275 kindly also see.
My lord will see 275. My lord will get the entire sufficiency of notice.
275.
Yes. Review petition 275.
Up to 2012, connected.
Same arising out of one order, man. 5 review petition 5.
275.
Yes.
My lord.
Yes.
Sushtidhar Jana.
Yes.
264 plus 83
Yes.
We are not a party.
What is the message to admit my person?
Consolidated possibility not side is possibility the LRs of deceased forward of the Das, who is not a party in this record but added as a proposed opposite party number 18 in which case number so which is at flag C. Filed by the addition of filed for addition of parties.
Ahmed is not my case.
There are several review petitions.
Yes, sir.
Only one order, man. One order. Individually they have filed.
How many review petitions are filed against what? What is the date of that order?
That order is, sir, dated.
Sufficiency of notice.
No. Order dated, which is subject matter of challenge, 31/7/2012. In April number 177 of 2011. Same order has been challenged in all the review 4 applications.
Total 4 or 5 review petitions.
5 review.
FA number 177 of?
Yes.
2011.
11.
Disposed of on 31/7/2012.
2012.
Yes, sir.
What was that order?
That order, just so that. I'll show that order. Sir, kindly come to that review application. I have enclosed that.
Honorable Justice Das.
Justice Honorable Justice Das, sir. Para 6. I did not take your worship to in details, but I'll show your worship how error apparent in the face of the records.
For a moment, give me the list of
review application.
Give all review applications.
All the review applications. Yes, sir.
Review application. RVWPET.
Yes.
They are called RVWPET.
Is the review.
264 of 2012.
Right.
Yes.
Number 1. Then
275.
275 of
12.
2012.
276 by 12.
Right now.
292 by 15.
292 by 15.
292 is not arising out of that. 292 of 50 is not arising out of that.
Sorry, 234.
234
of 12.
I am appearing 234. In the past case.
3 review petition.
4
review petitions.
4 review.
4 review petitions. Whether are they filed within the period of limitation?
Sure.
Yes.
Sure.
They are.
Notice has been issued. Notice has been by the Honorable same judge.
Notice was issued.
Yes, sir.
Whether were they filed in the period?
That year 234 was filed within the limitation.
Notice on limitation also. Limitation.
How many years of delay?
This was filed In 2012, there was no limitation so far as 234 is concerned.
234, no limitation.
No limitation.
275 there is limitation.
75
There is
limitation.
no issue.
275 there is limitation.
275, how many days delay?
That's it.
Higher number.
291 and 275 both have limitation. So 19 is also limitation.
Any applications are filed for condonation of delay? How many days delay?
Just wait.
290
How many days delay?
How many days delay? Any objections are filed for
I don't think.
these applications?
No.
Just no.
कितने देखो ना delay कितने
No objections are filed. So we will condone delay. Then we go to the next level. In only 2 matters there is delay.
2 months.
No, three.
Three matters.
Delay. One matter delay, that is 234 of 2012.
31/7 is the judgment, my lord. 30 days is the time. It is filed in September. 25/9/12.
2 minutes.
Around 2 months. Roughly 2 months.
Roughly 2 months.
Roughly.
Out of there are 5 matters, four matters.
4 matters.
Out of 4, in three matters there is delay. Which are those matters?
264,
Except 263.
Yes.
234. Except 234.
264, 75, 276.
275, 276 are filed with delay of about 2 months or so, and an application and separate application supported by seeking condonation of respective delay. First now. No objections are filed to these applications. First now. Delay being short and some plausible explanations having been offered, comma, the same is condoned in all these cases. Accordingly, the subject application are disposed. Yes. Now,
Lord, I just take leave from my Lord. Lord, I'm calling another.
no problem. You can have a round and come back. You will be very happy. Though I may have to be.
Since delays are condoned, you have to let them serve the copy of the.
Then what are the necessity to argue the matter so much?
Next.
Next, you also kindly look to review petition number 275 of 2012.
So, what is the scope of review petition?
Yes, sir.
Review is under which section?
So far the review is concerned.
Yes.
High Court rules, read with order 47 rule 1.
Just show that.
That you also kindly see the cost title. Chapter 8, Rule 23 of the Orissa High Court rules, read with section 114 of the CPC and order 47, Rule 1 CPC.
36.
The review is maintainable.
Yes.
Any review is maintainable?
No, sir, review is not maintainable. I have got the judgment.
Give that.
Sir, creation of statute.
Give that.
So this appeal is creation of statute, and that statute, that is Special Education Act. It doesn't have a scope for review.
In the Education Act, there is no provision for review?
No, sir.
This is appeal under the Education
High
Act.
Court rules, sir. This is High Court rules.
Appeal to the High Court.
Let us read the High Court.
Sir.
No, what he says is.
He says that it is a special statute. So that
Special statute
Sir.
and appeal lies to the High Court.
Sir.
Second appeal. First appeal. Unless there is a provision for review,
Sir,
how review is going to be entered?
so far the review is concerned. So far the Orissa High Court rules is concerned.
Read the Orissa and High Court.
I have not said.
This is a land acquisition matter.
No, land acquisition, that is also a special statute. Education Act is
That
also
is something
Under this These are all first year law students will be knowing. Really, first year law students will be knowing, perhaps last benchers also. I am asking, under this statute, there is no provision of review. That's your contention. If under the special act, if review is not provided, the review, whether the CPC is applicable to them or not.
CPC is applicable to this act in the case of this 24B applications to certain extent. Not in all.
Which is that section?
Section 24B.
Read that.
Chapter 8. Chapter 8.
Yes, sir. Show how should it, if review is maintainable. You have to show it.
Yes, sir.
Yes.
But I am not.
So the tribunals shall have jurisdictional power and authority to adjudicate all disputes and differences between the managing committee, as the case may be, the governing body of any private educational institution and the teacher or employee of the institution of a form of state government or any officer or authority of the state government relating to or connected with the eligibility, entitlement, payment of or non-payment of granting aid. Any person aggrieved so and so by pertaining to any order of the institution may make an application to the tribunal to resolve this grievance. And
the procedure.
Subsection 5. The tribunal shall not be bound by the procedure laid down in the civil procedure code, but shall be guided by the principle of natural justice and subject to any rules made by the government shall have the power to regulate its own.
Principle of artificial rule on applicable.
Then 24C. Appeal to High Court. Any person aggrieved by an order or decision of judgment of the tribunal may prefer an appeal before the High Court within a period of 60 days from the date of such order or decision or judgment. That's all.
Yes, which provision provides for review?
Sir, kindly look to the chapter 8, rule 23 of the Odisha High Court rules. Sorry, I have not brought the.
No, it's not.
Sorry.
I will have that book. No? If we have one more book, just share that. Give that book to learn.
Thanks.
You have that?
No, sure.
Yeah. Okay. This also same. Educational balance. This is separate text also. So we'll hold this separately so that we can be on the same pages. Right.
Sure.
Apex Court said, at least in 3 decisions, appeal is continuation of original proceedings. So it is a proceeding continuing from the tribunal. Tribunal is not bound by the CPC. Where is that view?
Tribunal is not bound by the CPC, but certain procedure there that is under the tribunal's rules. Under the Act, there is a rule.
Sure.
So to that extent, CPC is applicable.
Sure. That is extent
Yes.
that is considered by the Apex Court in Jyoti Basu versus Devi Prasad Ghoshal, 1983 Supreme Court. Take out. 90 something like that.
The rule is Orissa Education Tribunal's Rules 1977.
Correct.
That if you also look to.
Now, how when the statute, parent statute says CPC is not applicable, how can the rule provide for the application of CPC?
There is no such provision, I think, under the Act.
No, there is subsection 5.
There is no such 24B subsection 5 also.
In so many words says the provisions of CPC should be applicable, but the principles of natural justice shall be.
That's right. That is there.
If CPC is excluded, then this is a super tribunal. This is not under 227 also. This is an appeal under the special act. Unless the act provides for review.
Language says also the tribunal shall not be bound by the procedure laid down in the Code of Civil Procedure, but shall be guided by the principle of natural justice and subject to any rules made by the government shall have the power to regulate its own procedure.
Only proceeding.
One procedure.
But review is not a procedure. It's a right.
Sir,
It's a very feeble right.
Sir, yes, it's not a right like that of the appeal. That's right. That's right. But we may read them also.
That's right. We have been taught by Professor Seshadri, the great professor, now he is no more. He said, unless the statute gives power of review, there is no review. Any number of decisions in administrative law. By he, in fact, SP Sate, IP Massey, Jain, DK.
Sir. But here is a case. So far as your lordship says that again we will have to verify. But so far as the High Court rules,
sure that.
Sir, page 50 of your lordship book.
High Court rules apply to whom?
Any applications which you to proceeding before the application. Any application.
But this is not an application, it is appeal.
Sir, appeal also look
Let
at
us
that.
read.
That's right, that's right. Can we come to page 50, subrule 23? When on any application for revision or review, the record is sent itself when received be laid before the judge or judges who made the order for a decision as to whether the application is to be admitted or rejected. Then
let us understand the language of
yes. Then section 114 CPC number.
The 6 is an objective right.
This presupposes their provision providing for review. It is not an island provision. It does not recognize right of review at all.
Sir,
if at all review is there, when review is moved, what he should do? That is spoken.
That's right.
So that section.
Possibly, I am not in a position to answer your lordship unless I will go through the entire Code of Civil Procedure as well as the High Court rules. There are also some certain judgments so far as the High Court rules is concerned where it can be applied. In a case, whether the appeal, second appeal, all these.
They are different. They are different. Suppose if appeal lies under the provisions of CPC, then right, there are such 86 opinions. But when appeal is against the order of the tribunal, this appeal is continuation of the proceedings that pended at one time before the tribunal. CPC not being applicable.
Sir,
Special Act not providing.
Sir, so far the 24B and 24C also look to the provisions. There is so far 24C is it should be isolated from 24B. Though the order of 24B is the subject matter of challenge and 20, but the 24B, the provision which you also have now read, that will be only confined so far the tribunal is concerned. So far the High Court is concerned, 24C.
Correct.
I hope so.
Assuming that you are right.
That's right.
One of the
only question
in your favor.
Sir.
Where is the power of people?
Sir.
24A is also a provision there.
Read.
24AC, that with constitution of the tribunal. C6, sorry. The order passed by the tribunal shall be enforced under the Code of Civil Procedure 1988. In the case, same manner as if were declared in the civil code.
Read again.
Order. The order, shall I read the entire provision?
Yeah.
That is there. Capital A.
24A of?
This Odisha Education Act. It's just previous, 24B prior to that. That is there. Tell him. Page 150. 158. Page
158. In this
same book.
May not be. Yeah.
No, it's same book because that is a cover new book, but it's an old one. Probably that's
158.
Can you see? Verify that. 24A.
24A.
Is it the same matter?
Yes. The state government.
Constitution of the tribunal. The
state government by notification.
Constitute
one number 2.
Having such local jurisdiction.
Consist of number 3.
One person. The tribunal shall have the power to call for records proceeding relating to dispute and shall, after giving parties concerned a reasonable opportunity being heard, dispose of the dispute. appeals preferred to it. In disposing of an appeal, the tribunal may such consequential order issue such direction as may be deemed necessary for giving effect to its decision. The decision of the tribunal shall be final and binding on all the parties and shall not be called in question in any court of law. The order passed by the tribunal shall be enforced under the Code of Civil Procedure in the same manner as if it were a decree of the civil court.
Civil court.
So thereafter, my lord, 24p, the procedure.
1 second. As to how it should be executed,
That is the procedure 24.
Order 21 will apply. Only that is nothing
That is
beyond.
24A.
Huh?
24A, my lord, 6. 24A 6.
24A6 provides for
Execution of that order.
execution only for the enforcement of the said order.
Order by the tribunal.
Okay?
Yes.
Only order 21 is taken
24A. Now 24B. 24 is the adjudication of the tribunal.
by the tribunal.
By adjudication by the tribunal. Tribunal shall have the power, jurisdiction, power, and authority to adjudicate all dispute differences between the managing committee or the case may be the governing body of any private education institution and any teacher or institution.
Substantive power is. Go to 2.
Any
Person
person
agree.
aggrieved by the order pertaining to any matter jurisdiction tribunal may make an application to the tribunal for the redress of his grievance.
Go to 3.
3 is the limitation. On receipt of an
May not.
application, this
Provided that
no application before the tribunal seeking claiming for granted against the state government.
not applicable to you.
This is not.
Go to 5.
4. Tribunal shall admit the application. This
No,
is the
that does
procedure.
not apply.
5. The tribunal shall not
Shall
be bound
not
with the
be
procedure.
bound by the
This is
procedure.
while deciding the issue.
Why? No, kindly read down.
Tribunal
In the Code of Civil Procedure 1908,
shall not be guided
shall
by
be guided by the
justice
principles of
to any
it
rule made by
excludes
government.
CPs.
Yes, for adjudication by the tribunal itself. When there is an adjudication procedure, the tribunal may not be guided by the CPC. However, for the purpose of notice and all these things, whatever there in the rule itself, the tribunal rule 77 prescribes how the notice is to go, how this summon,
Only that.
all these things. That is the
CPC, you
procedure.
have to keep it aside.
So now, madam, 24C, LC.
24C.
Yes, appeal to High Court against this order of the tribunal. Any person aggrieved order or decision or judgment of the tribunal may prefer an appeal before the High Court within a period of 60 days from the date of such order or decision or the judgment. So against that order, my lord, appeal lies to the Hon'Ble High Court. That is has been filed. This FAO was filed. There was some mistake or some error apparent on the face of the record. Therefore, the review was filed.
Where is the power?
Yes, that is the only question, my lord. This is the fact I'm just placing. So there was error apparent on the face of the record. That is why the review is filed. Now the question is whether the tribunal, this Hon'Ble Court can hear an review against such an order of the court. That is the only point.
That's the only point. Addition to tell all these cases.
Yes. So my respectful submission is, if my lord will permit me one day even.
Court, Apex Court has gone one step further.
Yes.
So that it may help you. Here is a provision which excludes CPC. There was a provision which invoked CPC selectively.
Yes.
Then the question arose whether CPC as such is applicable. Take out that judgment. Do anybody want? 1983 Supreme Court 869 or 969, something like Jyoti Basu versus Devi Prasad Ghoshal. Apex Court said CPC is not applicable. Where even when it was under the representation of people like 1950.
Yes, is that in there?
Justice O. Chinnappa Reddy's judgment. Take out that judgment.
Devi Ghoshal.
Correct.
'82,
83, maybe 80. My memory is playing trick with me nowadays. Read that paragraph. There is a paragraph. Read that. Election matters or special matters are governed by the statute. That provision, that paragraph, I read long ago. Read that.
That's the fact the court has said. It says that the provisions of the Civil Procedure Code
invoke to permit that which the Representation of People's Act 1951 does not permit.
Yes.
The Civil Procedure Code applies subject to the provisions of the Representation of People Act 1951.
Yeah.
And any rule made thereunder. Section 87(1) expressly says so. When the Act enjoys.
See, it said you can invoke the provisions of CPC. There the Supreme Court said it is not full CPC. Here is a provision which excludes the CPC. It will put that CPC into a cover and keep it aside. Where is the power to review?
My response submission, subject to ballot, I will go through again the High Court rule. But in extempo, I am just submitting one line subject to approval. But my response is that 24B which excludes CPC, it only 24B only speaks about the procedure and proceeding of the tribunal.
Correct.
For the tribunal, the CPC is not applicable.
But the High Court, otherwise it would have been.
But my response, there I want to make out the case.
No.
I have.
No, this is a proceeding, continuation of appeal.
Yes, appeal I came.
Yeah.
Then now my appeal is to be decided. I put a question to myself, my lord.
You can put to me also, no problem. No, I will be happy to try to answer.
Yes, obliged, my lord is more knowledgeable than me. But if the case come to the High Court, and now High Court in the session of the matter under 227 of the Constitution, because the 26, even if let us say 26,
no,
24C, my lord. Yes, my lord.
Only statutory appeal.
Yes, the 24C Act, High Court has its procedure and everything as per the statute of the Odisha High Court rules. Whatever it is there under the Odisha High Court rules. We cannot say that. We cannot say. That is my understanding, but it may be wrong.
Your understanding is unacceptable. I don't say right, wrong. Unacceptable to the
yes. That I have to go. That let us some examine some point.
No, there is nothing. Review is not maintainable.
That is the.
That's the only point. Review is not maintainable. We will not undertake the deeper examination unnecessarily in this. Otherwise, there by now there would have been some decision holding that review is maintainable.
No, this
the fact that all these years there is no such decision. This means that all judges understood the things rightly. Except Mr. Dash.
No, except review has been accepted in many cases. At least for me, my lord, I have the cases just now I cannot recall it. Review has been allowed against the tribunal's order here.
It's not that. Question is entertained by this court or not is not the question. It is a question of fact. Whether this court entertained the review. Yes. In 2013 it entertained, 15 it is entertained, 21 entertained.
Issue was not.
Questions of fact.
This
question
issue was not
is whether review is entertainable.
This issue was not raised or not. That is the point. That is the only point. Whether this point was answered. Put to the parties and it is answered. If it is not there, permit me, let us have some, because this is the first time it is coming before my lord. So let us have a chance, because many cases will come in this way.
Many cases will go.
My lord, kindly see, there is a judgment. According to purpose 24C once again. Against any order, the order of the tribunal, judgment order 24C, my lord. Kindly have a glance. I will refer to another judgment. What does it say? It says, any person aggrieved by an order or decision or judgment of the tribunal before an appeal. One judgment of this honorable court is, my lord,
page number of
162, man. 24C. Again, I have yes.
Law, we were told.
Academic,
we were told law is a jealous mistress who attracts continuous attention.
Well, can you see? Any person. 162. Page.
Yes.
Any person aggrieved by an order or decision or judgment of the tribunal may prefer appeal before this tribunal. In this situation, but one of the judgment of our own High Court is that even an interim order passed against that, appeal has come before this honorable court.
Because the order is there.
But on this honorable court judgment is that no, it is not maintained.
Only final order.
But
Only they say it is only final. The Honorable Court has said final order. That is pending in the writ appeal. But now writ appeal, the full bench judgment of this Honorable Court has said writ appeal is not maintainable against FAO. So that is to withdraw and to prefer in the Honorable Supreme Court. But this is also in the judgment of this Honorable Court. I am just a coordinate bench has passed that order. But a plain reading of this statute, any order, decision or judgment, because tribunal can pass an order, pass a judgment or decision, whatever it is. So any order includes, my assumption is interim order also. But that interim order the Honorable Court has said not maintainable. So that is sub judice. So these are the judgments also. So once my lord passes, that judgment is now staring at us. So we have to prefer Supreme Court is not for the Odisha people. It is quite difficult.
Even this you have to go on. With that case, take this case also.
So therefore, I am submitting my
only one fire.
Therefore, before my lord passing the judgment today, 1 or 2 days, let us then judgment so that it will be beneficial for the litigants, not for us.
I just found a division bench judgment of Delhi High Court, which I have cited also in another case. This is perimeter provision, so far as the tribunals, section 24B and 24C. To answer the first question, it would be necessary to excerpt section 22 of the Recovery DRT Act, not the Act, which provides the extent to which CPC binds the DRT. Quotation, section 22. Procedure and power of the tribunal and appellate tribunal. The tribunal and appellate tribunal shall not be bound by the procedure laid down by the Code of Civil Procedure 1908, but shall be guided by the principle of natural justice and subject to the provisions of this Act and of any rule. The tribunal and appellate tribunal shall have power to regulate their own procedure, including the places in which they shall have their sitting. Exactly the provisions provided you just now read, that is just like this. 24C is this, 24 press conference. 5. So far the Orissa Education Act is concerned, the same. The tribunal shall not be bound by the procedure laid down in the
They have duplicated the provision.
Duplicated the provision. Now, then paragraph 12, the gist of the, it must be appreciated that while the DRT is not bound by the CPC under the provision, it is empowered to regulate its own procedure, subject to compliance with the rules of natural justice and the provisions of the Recovery Act and any subordinate legislation under the Act. This is why the DRT is empowered to use rules of the CPC as part of the procedure to be followed during proceeding. Since the discretion to regulate the procedure is conferred on the DRT in section 22(1), we just now read, the view was accepted by so-and-so Industrial Credit so-and-so 99(6) SCC. The court observed that when section 22 of the Act says that tribunals shall not be bound by the procedure led by the Code of Civil Procedure, it does not mean that it will not have any jurisdiction to exercise the power of a court contained in the Code of Civil Procedure. Rather, the tribunal can travel beyond the Code of Civil Procedure, and the only fetter is that to put it on its power is to observe the principle of natural justice. Thus, as the DRT is empowered to regulate its own procedure, it is foreclosed from applying section 10. Of course, that was the case. Section 10 CPC proceeding in WPC number so and so, and therefore the argument of that the DRT is not bound by the CPC.
No, section 10 is a doctrine of sub judice.
Yes.
Section 10 of CPC enacts the doctrine of sub judice.
Sub judice.
If one matter is pending,
in one court, the other.
So independent of section 10, that doctrine is applicable. But where is the review? Review is a substantive power throughout in all the colonial country. Unless power to review is given, there is no review power.
That to have to examine, but it's a very large the judgments are there.
So you need
yes, at least some research.
We'll call this matter tomorrow.
Not tomorrow. Perhaps we call it next week Monday.
Because I have already heard. Again,
this aspect
is not for only point it can be.
Now you get.
No, you get first day after tomorrow. With the review also. It is not that it is for Vasan in this case.
I only pray that bench be changed.
But the same bench has issued a notice. Well, who has passed the order?
That's it.
That is it.
Since you also raised the question.
Yeah, delay will continue. Delay will continue. Learned Counsel Shri
Shukumar
Ghosh, representing the OPs are respondents.
No, I am representing the governing body.
There is no, who is that, sir? It is called OP or a respondent? Respondent number, respondent governing body raised a pure question of law as to the maintainability of review. Contending that the Orissa Education Act 1969 in so many words excludes the application of CPC except for the enforcement of orders of the tribunal, the review is not maintainable. First time. At this stage, counsel appearing for the review petitioners sought time to examine the issue in a greater detail and come back. First time. This is a very old matter. These are all very old matters. First time. Therefore, a short accommodation is granted to the review petitioners as for first. Call these matters on
19th or 20th?
20th. 20th, we have many matters. Post it on 19th. 19th. Just examine, you also examine. That Devi, that yeah. 26.
May I please?
Yes.
But shall this petitioner approach this Hon'Ble Court?
Serial number 56.
Asked by this Hon'Ble Court, the lordship is found at Annexure 4, my lord.
Yes.
It was the innocuous order, my lord. This Hon'Ble Court is directed to consider the case of the petitioners in the light of the judgment rendered in my lord Prafulla Chandra Sahu and others. If the application is made within 15 days, that shall be considered by the authorities within 4 weeks thereafter, ma'am.
What was that, Prafulla Chandra? 2003 one OL?
My lords.
What it said? Where is that
it
judgment?
speaks about the granting aid. Granting aid to an institution.
Granting aid to the institution.
My lords. That thereafter
we
they
had
did not consider
these matters one particular day. Granting matters full day. Thursday.
My lord, it is, my lord, my humble submission is a petition. I have filed this petition for implementation of that. Content I did not file, that I cancel. I should have filed a content.
No.
Pardon, my lords?
There is an order to grant granting aid to you.
No, my lords. No decision has been taken pursuant to this order. I could have filed a content, but I did not file. I cancel. But after passing of this order, I can make a recommendation to the authorities on 12/5/2017. No decision has yet been taken by the authorities. That's why, because I could not able to file the contempts, my lord, I filed this for my lord, implementation of that.
That will be hit by res judicata.
My lord, I cancel. But my holy prayer is, my lord, if you will permit me, I can file a writ application afresh. Because my right will go forever, my lords, because of the process. It's my only humble submission. I know it, implementation order is not maintainable, my lord.
Second writ petition is not maintainable because there is already an order in your favor.
My lords.
What we will do is, well, what is the period given in that petition to consider?
My lords, it was given period of 5 months from the date of filing of the such representation.
You filed the representation when?
My lord, on 12/7. My lord, sorry, my lord, 12/3/2017.
2/3, huh? 12/3.
2/3.
2/3 is ordered.
Yes, my lord, 12/3. I have submitted the representation. Your lordship will found it as running page 14 of my brief. The last portion of the representation.
Brother, you consider we will make a little modified order. Otherwise, he will not get the order. There is already an order.
Yes.
He could have moved the contempt. And there is a government usually does not respect the orders of the court. Anyway, that is the practice in your state. Therefore, we will make, we'll direct you to consider his representation in a time bound. Okay.
Yes.
Coupled with the direction for payment of fee of 1,000 rupees per day for not of delay, payable by the concerned officer. If such orders are made, they will not do like this. New techniques have to be found to treat unscrupulous officers. Otherwise, a citizen will be the slave. Your officers think they are all slaves and they are the lords. That is there. Because what you don't give respect even to the High Court. Take that. The short grievance of the petitioner is as to non-consideration of his its representation. Correct. Its representation dated 12/3/2017, which wherein he had sought for the facility of granting aid. First up, learned counsel for the petitioner, in all fairness, submits that his client had approached this court earlier in WPC number 21732 of 2016, and the same came to be disposed of by a coordinate bench of this court while order dated 2/3/2017, permitting the petitioner to make the representation and directing the authorities to consider if one is made. First of all, one having already been made, there is no consideration, and therefore this court should come to the aid of his client. First, next paragraph. When a question is posed to the learned AGA appearing for the respondents in this 9-year-old as to why the writ of coordinate bench issued by order dated 2/3/2017 has not been complied with. Brother, you come to page 9 now, Annexure 5.
My lords.
Order is dated 3/2017.
My lords.
But how can this be writ of 2016?
Well, it was taken up on 2/3/2017.
But your writ petition is of which year?
Of 2016, my lords.
How you mentioned that in this writ petition?
Pardon, my lords.
This writ petition,
my lords,
is of the year 2016.
16.
But you are mentioning an order dated 2/3/2017. You have traveled very well in
the order is passed on 2/3/2017. Though is the writ of 2016. The order is passed on 2/3/2017.
Then how could you make it annexed?
Maybe a typographical mistake, my lords.
Your representation is of 2017.
My 20.
But writ petition is 2016.
Well, it's my humble submission is the order is passed on 2017.
Correct. But how could you produce that in your 2016 writ petition?
In the representation, my lord, I have quoted that.
WP is of which year?
WPC is of 21732 of 2016.
I am asking you if this is
This petition is for implementation of order. My lords.
He has not served a copy. Let him serve a copy, my lord.
You have to implement that order. He has made an application now.
A copy he has not served.
Yeah, he will give you now.
I would
give that copy.
My lord, I will give you.
If it was given also, you would not have cared. You have not cared for the order of the High Court, what you would do with the application. What you have written? Recall this order. Petitioner, the petitioner has moved application in a disposed of case in WPC 21732 of 2016, complaining that despite order dated
2/3/2017.
2/3/2017, whereby the petition was disposed of, the representation dated
12/3/2017
made in the light of the observation of the court order has not been disposed of. And therefore, learned counsel for the petitioner seeks one more order to the respondents to pass orders on the representation. First off. Next paragraph. Learned AGA, on being asked as to why the order dated 2/3/2017 of the coordinate bench is not complied with, he is not in a position to answer. First off. However, he submits that in terms of the order now being made on the subject application, he would instruct the jurisdictional officials to take a decision on the subject representation, if already one is not taken. First off. He requests the court to keep all the contentions open so that a meritorious decision can be taken by the statutory under the provisions of Granting Aid Code. Okay. Is there Granting Aid Code?
No, code. There is no code for Granting Aid.
No GI code?
Tribunal. Being filed before the tribunal.
And this is not a case of dispute now, as of now. First off. Next paragraph. Is the first off. Learned counsel appearing for the petitioner applicant is agreeable with this proposal. First off. Next paragraph. In view of the above, application is allowed. A direction has been into the OP number. One.
My lords.
OP number 1 to consider and dispose of, or to cause consideration and disposal of the subject representation in accordance with law within a period of 4 weeks, reckoned from this day. First off, should the delay be made, the concerned OP number 1 shall pay a sum of rupees 1,000 per day to the petitioner institution for the first 1 month and rupees 2,000 for the period next following. This amount on payment to the petitioner may be covered from the official concerned personally from his salary. Now the consideration takes place. Copy to be acted upon. Give copy of my application. Yes. You have copy to be acted upon.
Item 57.
May I please that? Now, petitioners are Group D employees, my lord. There is provision in the rule that 20% is to be reserved for the promotion from Group D to Group C, my lord.
Group D
to Group C, my lord.
Group C. 20% in service.
20% out of vacancy that is to be for promotion from Group D to Group C. Initially 10%, that was subsequently enhanced to 20%, my lord. Since petitioner's case was not considered, they approached the Hon'Ble Court. The Hon'Ble Court disposed of that a case should be considered. They have rejected. That was contempt was filed. After contempt, my lord, they rejected. Rejection is under challenge, my lord. Though they have not filed counter, now they are taking steps to fill up the post. I have filed an IA on the ground that since rehabilitation persons are there, they have to fill up the Group D and
80% let them fill up. 20% let them fill up. I will stop you from taking up a promotion.
And they have to give counter, my lord. They are also not.
Take advantage of absence of counter. I do not understand lawyers arguing. They are not filed. Take maximum advantage of that.
My lord, my lord.
Ask them you should not file counter. That helps you.
My lord. Copy the idea. Nowadays, copy, if not file copy, case will not number, it will reflect everything.
And if you copy, they will ask one more copy.
No, I am asking for I.
Give one more copy.
More than agent.
Grievance of the petitioner is as to non-consideration of. Or suppose if we say they have rejected that. On what ground you have rejected? If the rules provide for 20% for Group D to C, on what ground you are rejecting?
My lord, have already passed in similar case, keeping 20%. I have supplied, my lord.
It's already there.
Oh, in another case, my lord. In another case. Do that. Kindly.
I have made this ordered.
My lord. Last paragraph, my lord, kindly see.
With a small mistake, except this you do. Same. Call this matter along with WP number. Sorry. So, same order. Don't fill up. Unless we do such orders, you will not care us. Okay. Yes, 56 over.
58. 58.
58.
58. I am appearing on behalf of the university, OP2.
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 Who appears for the petitioner?
Miss Learned Senior Stadas. Item number 55.
All right, call this matter week after next to enable counsel for the petitioner to come and argue. Next.
Item 59.
I have already filed the requisite, which may kindly be accepted.
Requisites you have filed now?
I have already filed.
Belatedly. Requisites now furnished belatedly be accepted.
Item 60.
16.
61.
60.
60 has already been.
60 is there.
So 60 has been adjourned.
Adjourned.
Yes.
First one.
In the first hour, it has been adjourned. Will also be take up item 61.
61?
Yes.
Take out 61.
Yes.
Mandamus 2?
My lord, here I have challenged the rejection order under Annexure 9. My claim for lecturer group A scale and reader state scale has been rejected.
On what ground?
On the ground that I have not been included in the common cadre of lecturers and I am not under the direct payment system. Your Lordship may kindly turn to the impugned order that is under Annexure 10.
37.
No, Your Lordship may kindly come to page 44. 44 of Annexure 10. The impugned order. Last paragraph, paragraph 7. Whereas the benefit of promotion as per placement rules 2014 shall only apply to the junior lecturers/lecturers in non-government aided colleges who have been approved in the pay scale of 9,300-34,800 with grade pay of 4,600 under ORSP rules 2008 initially, and who are in the common cadre as per section 10C of the Orissa Education Act 1969. As on the date, the petitioner has not entered in the common cadre, having not been approved under direct payment scheme in the pay scale of 9,300-34,800 with pay of 4,600 under ORSP rules.
7 is the ground.
Yes.
On which they have rejected.
Yes. Now you'll also may kindly see the rules.
Says, according to you, 7 says, you should be a member of common cadre.
Common cadre. Well, first you will also may kindly see the placement rules of 2014. What are the criteria?
Yeah. Do you have
Annexure 8, page 33. I have annexed it.
Annexure 8, page 33.
33. My lord, the nomenclature of that rules is,
you're right.
1-1. These rules may be called the Orissa Non-Government Aided Colleges Lecturers Placement Rules 2014. It came into force on 1st day of January 2014. Now your lordship may kindly come to the relevant provision, Rule 3. These rules, my lord got it?
Yes.
These rules shall apply to the junior lecturers/lecturers in non-government aided colleges who are in the pay scale of 9,300-34,800 with grade pay of 4,600 under ORSP rules 2008 before commencement of these rules. This rule
One second. Let us understand. What does it say? In your words, tell us.
My lord, my submission before your lordship says, prior to coming into force of these rules, because the rules came into force on 1st January 2014, one must be in the pay scale of 9,300 to 34,800 with grade pay of 4,600. 4,600. Then your lordship may kindly come to Rule 4, eligibility criteria for placement. In order to be eligible for placement to the grade of lecturer group A scale of pay under Rule 9, a lecturer as covered under Rule 3 must have A.
8 years service.
My lord, 8 years of service that is not required for me
From
because
the approved date of joining.
Yes, my lord, that is not required for me because that is relating to a selection board sponsored lecturers. I am not a selection board sponsored lecturer. Your lordship may kindly come to B, 4.1b. I am concerned with that.
Completed
8 years of service from the date of receiving a full grant in the post of lecturer in case appointed by the management. Well, my case is covered under this. Then your lordship may kindly see the explanation. Explanation appended to that rule. For the purpose of clause B and C of this rule, the expression full grant
shall mean completion of 9 years of continuous service from his/her approved date of joining. My lord, full grantee rate means one must have completed 9 years of service from the approved date of joining. And D is
Your approved date of joining is what?
My lord, my approved date of joining is 1/8/1993. Your Lordship may kindly see my approval order. Annexure 3. Annexure 3, page 17. My appointment, serial number 3, Loknath Behra, lecturer in mathematics. My approved date of joining is 1/8/1993. My lord got it?
Loknath Behra.
Yes, this the third column.
Date of joining is there.
1/8/93. That because my appointment was approved with effect from that date.
Where is that?
But this is the approval order.
Where is the word approval?
But pursuant to government order number such and such, payment of block grant with effect is hereby accorded in favor of, as per the detailed given below in terms of Orissa, such and such rules. This is the approval order. My lord, then your lordship may kindly see.
Kindly do not question. I have not understood. I am difficult to agree with you with the text of these orders. Is hereby accorded.
Accorded.
What is that accorded?
That means approval is accorded. Because that, my lord,
it doesn't have any other meaning at all.
Yes. Because payment of grantee rate is always, approval is only for the purpose of payment of grantee rate. That has already been decided by this honorable court. Otherwise.
Not to the appointment.
Yes. But appointment is approved from the date of joining and grantee rate is given. Because once the.
Two things. One, approval of any other word approval is defined under any rule.
Your lordship may kindly see. Yes. 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 Your lordship may kindly come to page 18, next page of that very approval order. Well,
approval order of block grant.
Approval order for
August. This is approval order only.
This is approval order. Here my appointment was approved with effect from 1/8/93. I received block grant as per the grantee order of 2009. My lord.
So you will fit into 4(1)(b).
Yes. Then your lordship may kindly see, after 9 years, well, it will be counted from 1/8/1993. 9 years is completed with effect from 1/8/2002. As per explanation.
36/2002. 31/7.
1/8/93 is the date of.
Therefore, it will be 31.
No, yes.
Anyway, even if it is taken as 1/8.
1/8, then also 1/8/2002.
9 years over.
9 years over. Then, my lord, as per the placement rules, plus 8 years. Your lordship may kindly see clause 4B again. Completed at least 8 years of service from the date of receiving a full grantee rate in the post of lecturer in case of appointment by the management.
Private management.
Private management.
Which is given grantee rate.
Grantee rate. My lord, so, my lord, I completed 9 years with effect from 2002. That is 1/8/2002 and plus 8 years. So I became eligible to get lecturer group A scale from 1/8/2010. Because it has to be read with the clause 4(1)(b), read with the explanation.
Explanation to?
Explanation to rule 4. 4(1)(b). 4(1).
Where is the explanation?
Well, at page 34, your lordship may kindly see. For the purpose of clause B and C of this rule, page 34 of that placement rules of 2014. 1A, B, C, then explanation.
No explanation is not.
Right, page 34.
A, B, C.
A, B, C, just below C.
A, B, C. D is there. Explanation. You are right.
Yes, explanation. For the purpose of clause B and C, I am concerned with B of this rule. The expression full grantee shall mean completion of 9 years of continuous service from his/her approved date of joining.
So with effect from 1/8/93.
That is
1/8/93.
Yeah,
1/8/93 plus 9 plus 9.
Plus 9.
It comes to 1/8/2002, according to me.
1/8/2002.
2002. Then your lordship may kindly see clause 1B, 4(1)(b). Completed at least 8 years of service from the date of receiving a full grantee date in the post of lecturer in case of appointment by the management. Plus 8 years. That means became eligible to get lecturer group A scale from 1/8/2010. Am I clear, my lord? 1/8/93 plus 9, 1/8/2002, then plus 8, 1/8/2010.
Plus 8 is a 4(1)(b).
4(1)(b). Yes. Because from the date of receipt of full grantee date, further 8 years.
When you got full grantee date?
Yes. That is the vital question. You will kindly see. Initially, I got 40% block grant in the pre-revised scale. Then your lordship may kindly come to Annexure 4 at page 20. The 2009 grantee order was amended by virtue of grantee amendment order of 2013 at page 20. My lord may kindly see the amended order, that is 2A. 2A, the eligible employees.
Eligible employees of
these colleges shall be paid 100% of pay at the initial rate plus grade pay in the revised scale of pay of ORSP rules 2008.
Means,
my lord, your lordship may kindly come. So far as ORSP rules 2008 is concerned, your lordship may kindly see this. ORSP rules, my lord, I was getting, your lordship may kindly see the last page, that Annexure 1 appended to the ORSP rules 2008.
This is the resolution.
No, this is rules.
Revised scales of pay.
This is resolution by the. My lord, your lordship may kindly see page 19, last page. Previously, I was getting the scale of pay 40% in this scale, that is 6,500/200, 10,500. Then, my lord, it was as per ORSP rules 2008. The corresponding scale is 9,300-34,800 with grade pay of 4,600. My lord, got it? My lord,
23.
I got scale in pursuance of this amended order of 2013 on 28/2/2013 because this notification came on, it was
December 2008 amendment it is.
Yes, amendment
scale of pay.
This came into force from the date of its publication in the Odisha Gazette.
It was published on
28 February 2013. At the top.
28 February
2013.
Where do you find that?
Well, that is there.
Column.
Extraordinary published by authority. That column is there. February 28. Well, in the underlined portion.
In the first page only?
First page, page 20. Extraordinary published by authority, then date is there.
Page
20.
20 of your
Annexure 4. Annexure 4.
Annexure 4.
That amendment order of 2013, by virtue of which the grantee order of 2009 was amended. Because initially I got 40% as per the grantee order of 2009. then 100% by virtue of this order of 2013. And this was published in the official gazette on 28 February 2013. My lord, that
page number?
Page 20, February 28, 2013. The captioned portion. Number 31, Cuttack, Thursday, February 28, 2013. And your lordship may kindly see 1(3) of the amended order. It shall come into force on the date of its publication in the Odisha Gazette.
So when it is gazetted, it takes force.
Takes force.
If it is if that date is taken,
28 to 2013.
28 to 2013.
Then your lordship may kindly see, as per this amended order, I got the scale of pay that is 9,300 in the pre-revised scale. In the revised scale.
9,300, 34,800.
800. 4,600. 4,600.
Grade pay.
Grade pay of 4,600 as per ORSP rules 2008.
Yes.
Well, your lordship will get it at page 23. Next page. My name finds place at serial number 3. Loknath Behra, basic pay 9,300, grade pay 4,600, and other things are there. And I got it from 28th February, last but one column, 28th February 2013 to December 2013 and onwards. And thereafter again the pay was revised. So I got it from 28th February 2013. This very pay scale, this very pay, 9,300 to 34,000 and odd, and grade 4,600. And the requirement as per the placement rules is, your lordship may again come to the rules. 2014 rules at page 33. My lord may kindly see rule 3 at page 34.
Page 34.
34 rule 3. My lord, this is the, these rules shall apply to the junior lecturers / lecturers in non-government aided colleges who are in the pay scale of 9,300.
So you comply with that requirement.
That is prior to 1/1/2014. I have got that. I got 100%. So I fulfill that condition and I am entitled to get. Now there are second.
Just tell me succinctly what the conditions are. Number 1. You should be a lecturer in the private management.
Aided college. Aided college. Aided college.
Lecturer for?
Lecturer in mathematics. I am a lecturer in mathematics. I was appointed on 2793 under Annexure 1. I joined on 1893.
1893?
Yes.
That itself is the approval order according to A3 because the conditions of that will say approval.
Yes.
So you completed 9 years on 1/8/2002.
1/8/2002. Then plus 8 years.
Plus 8 years required under 4B.
4B. 4(1)B.
4(1)B.
It comes to, that is 1/8/2010. So I am entitled to get lecturer group A scale from 1/8/2010. And after 10 years, that is with
the full grant in aid, it was granted only on 28/2/2013.
13. That is as per rule 3. Because that is the one who is getting that scale prior to commencement of the 2014 rules, which came into force on 1/1/2014, he is eligible.
Who appears for the...
And second, another ground they have taken, that I am not in the common cadre of lecturers.
That is not the requirement at all.
That is not the requirement. You will also kindly see.
Any decision on that?
Yes, yes. There is a ballot. Once a lecturer gets grant in it, he is automatically included in the common cadre.
Where is that?
But that decision you will also kindly see.
What is that? Common cadre is defined by any other?
Section 10C of the Orissa Education Act. You will also kindly see that. Education Act.
Education Act 1950.
Education Act, Your Lordship may kindly see that very book.
Educational manual.
Page 144.
First one.
Sorry, page 150.
150. How you have structured your ground of petition? Where have you stated in your ground all these things?
Yes, my Lord, I have indicated. Your Lordship may kindly see section 10C first.
Constitution of Common
Cadre, its consequence. 1. The state government may by order constitute a common cadre in relation to all or any class of employees of all or any category of aided educational institutions as may be specified in the order. Then provided that the state government may constitute a common cadre in relation to all or any class of employees of all or any category of aided high schools or upper primary schools for the whole state or for any educational circle as may be prescribed in the order. Then 2, before constitution of common cadre under subsection 1.
Come to 4.
Any employee who fails to exercise office in the aforesaid period shall be deemed to have opted for being observed in the common cadre. Then common cadre employees are liable for transfer. That is provided under sub-rule 6, subsection 6, subsection 10C, under the Inter-Transferability Rules 1979. In one of the decisions, this Honorable Court has held that since common cadre is already there, a lecturer who gets grantinate from the state government, he is automatically included in the common cadre. There is no need of
option.
Yes. Well, that decision Your Lordship may kindly see. My Lord. Copy to
Which decision? Which
my Lord, paragraph 14. Everything has been discussed. I will not waste Your Lordship's time. Your Lordship may kindly come to page 8, para 14. 12, 13 are also relevant, but Your Lordship may kindly see para 14. We further hold that all persons who are appointed in unaided colleges as lecturers in regular manner and receiving grantinate are born in the common cadre, and the petitioner being such lecturers are within the common cadre and liable to be transferred, which power is vested in the government under subsection 6, subsection 10C of the Act. And then for 12 and
how this conclusion they arrive at?
Your Lordship,
arriving at this conclusion, where is the reasoning part?
The reasoning part is, Your Lordship may kindly see para 13. On taking a holistic view of the matter, we are of the considered opinion that a common cadre of lecturers of all the aided colleges of the state have been constituted by the state government way back on 22/10 to 1982 by Annexure A. In the backdrop of the settled legal dictum that once a cadre is constituted of a service, all appointments made thereafter to the service are ordinarily made in the cadre, either as within the strength of the cadre or as temporary additions to the strength. We are of the view that when a cadre is constituted, all persons who are subsequently appointed to the service are
automatically appointed to the
cadre and become subject to the conditions of the service relating to the cadre. And so far as another ground they have taken in the impugned order, that since the petitioner initially got the block grant, as per the grantinate order of 2009, he is not under the direct payment system. He is not under the direct payment system. My Lord, may
it is credited to your account itself.
Yes. Your Lordship may
kindly to the institution and then to the account.
Yes. No, directly to the
account of the
account. Because my Lord, the college is an old college. The college is a category 1 college. It is receiving grantinate much prior to 94. I was appointed subsequently, but college has received grantinate much prior to that. It is a fully aided college. Your Lordship may kindly see sections, because so far as block grant concept is concerned, or the grantinate, for the first time it was regulated by Section 7C of the Orissa Education Act. Prior to that, orders were there regulating payment of grantinate. My lord, kindly come to page 137.
137 now?
137 of the education manual, that book. The 7C1, the state government shall, within the limit of its economic capacity, set apart a sum of money annually
Section
7C. 7C1, your lordship, may kindly see. The state government shall, within the limit of its economic capacity, set apart a sum of money annually for being given as grantinate to private educational institution in the state. Then subsection 2, no order according permission or approval or recognition under this act, whether prior to or after the commencement of the Orissa Education Amendment Act 94, shall entitle any private educational institution to receive grantinate. Then subsection 3 is not relevant. Then your lordship may kindly see subsection 4. Notwithstanding anything contained in any law, rule, executive order, or any judgment or order of any court, no grantinate shall be paid, and no payment towards salary cost or any other expense shall be made to any private educational institution or for any post or to any person employed in any such institution after the commencement of the Orissa Education Amendment Act 94, except in accordance with an order or rule made under this act. Grantinate where admissible under the said rule or order, as the case may be, shall be payable from such date as may be specified in the rule or order, or from such date as may be determined by this government. So all the grantinate orders were framed in pursuance of Section 7C4 of the Orissa Education Act. 7C came into force in 1994 by way of amendment incorporated in 94. Then your lordship may kindly see that is the relevant provision 7C7. Next page, page 138. Here, your lordship may kindly see how payments are made. A governing body or managing committee desirous of availing the facility of grantinate shall make an application for the purpose within such period, and such information and documents, including audited statement of accounts of the institution, as may be prescribed. It shall furnish with the application an undertaking to the effect that grantinate sanctioned for the purpose or meeting part or whole of the salary cost shall be disbursed directly to the employees concerned, and to refund any excess inadmissible payment that may have been made. Because direct payment system has nowhere it has been defined. Therefore, in the pension case, the coordinate bench of this Honorable Court has held, by interpreting the retirement benefit rules of 1981, there is no distinction between block grant institutions and full grant institutions, because all institutions are notified under Section 3B of the Orissa Education Act. Your Lordship may kindly see Section 3B. This is an old college that is not necessary. Your Lordship may kindly see 3B for academic purpose. Yes. Your Lordship may kindly come to page Section 3B.
115.
115. 3B. It defines aided educational institution. Section 3 is the definition chapter. Aided educational institution means
which is eligible to.
Means private educational institution which is eligible to, comma is there, and is receiving grantinate from the state government. This is one part. And includes an educational institution which has been notified by the state government to receive grantinate. But so far as the petitioner's institution is concerned, it has been receiving grantinate since long, prior to my appointment, that is in 87-88. It is an old aided college. And so therefore, my lord, that very question arose regarding direct payment system in that pension case, which has been referred to the Supreme Court. My lord.
No, how that is, all that is relevant to your case.
No, that is not relevant. That is not relevant. But
your case is 4(1)(b).
Yes.
Read with explanation. Then the amendment.
Amendment and condition and Rule 3. That I am in the particular scale prior to coming into force of the placement rules of 2014.
Automatic member of the cadre.
Yes. So cadre and other things are not relevant, but they have indicated in their impugned order. That much.
What do you say?
Yes, sir.
One second. Where is the ground you have taken in your petition of
Yes,
all
yes.
this?
Yes, yes. My lord, your lordship may guide this. What happened?
Para 10.
Para 10. Para 10, that is and in the rejoinder also I have explained it. That is para 4. 4 and 5. And management has also filed.
Management has filed objections.
No, management has supported my case and filed a counter.
Is it you?
Yes, ma'am.
Where is that your counter? Your rejoinder is to the counter of the management.
No, counter of the state.
State government. All right. What do you say, sir?
The first submission before my lord is he was getting block grants. He was
That
never.
difference will not because of the judgment.
Yes.
That goes.
Judgment he has not solved, the copy I have not gone through.
Give copy, we'll call it tomorrow.
Yes.
All right. All right. Call tomorrow. That's the only point which
No,
we need.
no, other points are
There?
yes.
Call tomorrow.
We have filed counter.
Supplying you.
Every time.
Milord, may mention please, item number 79. Interim order is still today. It may kindly be
Wherever there is interim order, continue all interim orders. We have said, we said wherever there is interim order, it will continue. Those people can leave the court so that others will be able to argue. If they have any grievance.
Regarding issuance of certificate or lordship, the small child, 2-child left. That's
85.
Yes, tomorrow lordship I pray.
Tomorrow. Item 75. What is the urgency? Real urgency. If there are real urgent, I will take the matter.
Urgency is my case 75. My legal hair certificate was issued in my favor. Then subsequently, another legal hair certificate is issued to another person, the brother of the petitioner, ignoring my case, even if without giving an opportunity of hearing. That may lordship state the subsequent order of the.
Now you have stay, no?
Stay, but we are taking advantage of the record correction has been there.
Item 72, person of the petitioner retired since 31/5/2018. Till date, his pension has not been released.
No pension is given.
No, my lord.
Absolutely.
Provisional pension is getting, but other pension. Last occasion, my lord, this honorable court directed to take instruction.
Getting
Item 87, my lord. I mentioned. Item 87.
You say
Person is not getting salary since 2000 last 4 years. Irrespective continuum. Stay is there. I file an application of lordship call it in the order sheet. Let the matter come disposed of.
No, we can't check.
I'm not getting the salary millers. Usually person I'm continuing. Last 5 years I'm not getting personal lordship millers. And despite the lordship not taking the matter.
What should we have?
No, not for I'm not putting this is proceed with it. This person is continuing and not getting salary. The last 5 years. For that sake I pray. Take millers, any day millers. The orders. Wednesday or office.
Item
87.
Item 66. What is the urgency?
My lord, urgency is the petitioner is at the age of 77, my lord. Not getting his revised scale of pay, he has filed 4 writ petitions. This is the last one. So on my memo, it has come.
Item 67, my lord. Item 67, my lord.
Yes.
Item 67, this matter is challenging the rejection order under section 91 of code, challenging the appeal, rejection order appeal, which is filed under section 91 of OD Act, my lord. Counter has already been filed and may be permitted 2 weeks to file the rejoinder and in order to be continued. Interim order to be
Okay.